try that.
Hello everyone, can you hear me now?
Yes, I can.
Thanks, Joe.
Yes.
Welcome, Kit. How are you?
Yep, I'm good. Looking forward to my picnic.
Which have you chosen the house you can do it with?
We're not allowed to be in a house, Steve.
No, sorry, the household, I should say.
Probably family, I suspect.
Yes. I've got a 19-year-old daughter holed up and she's frustrated because she says she's got friends at all sorts of different houses, so it doesn't really do much for her social life in Auckland, but there we go. Yes, Kate Casey, I see you there as well.
Morena.
Morena.
Yes.
Casey, were you listening in yesterday? I'm not sure you were.
I was, yes. I just logged in a bit late.
Okay, all right, welcome. Look, we will get underway. We're starting just a bit early just to work through the last of Denise's 42A report. So shall we just get straight into it?
Yeah, kia ora koutou. My name's Denise Young. I'm a Senior Planner Advisor in the Council's District Land Team. I prepared the Section 42A report for the Public Access chapter. I'd like to introduce Renee Davies, who is Planning and Design Lead at the Council. Her expert open space planning evidence is appended to my Section 42A report.
Thank you.
So she's available to answer questions throughout the hearing, and it's anticipated she'll be involved at the verbal and written right of reply stage of the hearing. Public access chapter is one of 7 chapters containing district-wide provisions that apply across all zones. The maintenance and enhancement of public access to and along the coast and water bodies is recognised in the RMA as a matter of national importance and is a key objective in the NZCPS National Policy Statement. The New Zealand Coastal Policy Statement. The public access chapter plays an important role in meeting these requirements through protecting access to and along the coast and water bodies. The proposed district plan, or the PDP, uses the overarching term of public access corridors, or PACs, to describe the collective of pathway types, including the coastal walkway and the Taranaki Traverse, which is a collection of formed and unformed shared pathways, which currently provide, or in the future may provide, public access to water bodies and the coast. In total, 20 PACs are identified on planning maps within the PDP. The network of PACs represent a strategic long-term approach, providing greater connectivity in the provision of public access to and along water bodies and the coast, and also to other areas of public open space in the New Plymouth district. The public access chapter contains objectives, policies and rules to manage activities within PACs. A total of 45 submissions and 9 further submissions were received on the public access chapter. Of the 45 submissions, 30 submissions, 1 from private individual and 29 pro forma submissions requested that the White Cliffs Walkway, which is to the north, goes from sort of Uranui to Ongapurutu, be included as a PAC and shown on planning maps. Other submissions were from Tangata Whenua, Network Utility Operators Kaungaroa, Heritage and Environmental Organisations, Federated Farmers, Taranaki, and 2 private individuals. The submissions focused on 6 primary matters that have formed the key issues in my analysis. These are explaining the concept of PACs, public access corridors, strengthening the recognition of cultural values and the involvement of tangata whenua in identifying and managing PACs, determining whether a new policy is needed to restrict public access in certain circumstances, the practicalities around avoiding activities which restrict public access to surf breaks, determining which activities are appropriate to locate adjacent to or within a public access corridor, and then inclusion and deletion of areas identified as public access corridors. My recommended amendments to Objective PA03 and Policy PAP47 and PAP53 aim to strengthen the role and relationships of tangata whenua in the identification and operation of public access to and along rivers and the coast. My recommended amendments to the chapter overview clarify that the PAC layer shown on planning maps is indicative and does not mean legal public access has been formed. Having read the pre-circulated evidence in response to my Section 42A report, I consider there to be two matters that need to be considered in the hearing. The first one, whether a policy is needed, which outlines the circumstances where it may be necessary to restrict public access, including for cultural, historical or spiritual reasons, or to protect existing infrastructure. And again, whether the White Cliffs Walkway should be included as a PAC and shown on planning maps. I've a few minor errors in my public access Section 42A report. So since publishing my report, I've become aware of minor errors. I've outlined these in a separate addendum, and I'd like to table a copy of that addendum. Can I just go through that?
Sure, thank you.
It's the same error that I've made through my 3 chapters in terms of my treatment of the consequential amendments from Waka Kotahi. So I've, in paragraphs 224 to 230 of my Section 42A report on the public access chapter, I've mistakenly applied the consequential amendments from Waka Kotahi, which seeks clarification of whether and or have been used between listed items within objectives to actually the policies within the text. So I've got, I have shown below the correct interpretation of that, and I have removed all my amendments to the and ors.
Thank you. Thank you. That's very helpful. I think we'll go through the same process, just high-level matters we'll cover off, starting again with Commissioner McMahon, first up better today.
Yep. Good morning, Ms Young. Look, I don't really have a lot. This seems to me to be a topic that hasn't been highly contested. That's not to say that the issues aren't important. And your recommendations in your Appendix 1 are really tinkering with, I guess, 2 of the policies, Policy 1 and Policy 3. And some minor changes to Rule, and Policy 4, sorry, and 5. And then some very minor changes to one of the rules, I think, was it P5? P6, R6, sorry. So, I guess what I'm really interested is methods outside of the district plan that can give effect to this public access topic. What in that space, what is the council doing?
In your permission, could I get Renee Davies? She's the public, she's probably better at answering that question.
Sure.
Through the Commission. So if you're in regards to things that are outside the district plan, and I've mentioned it in my evidence, is we try to implement the PACs through, or proposed public access through voluntary mechanisms. So at the moment, for example, I'm approaching landowners, and in fact landowners approach council. So we have had one example where a landowner adjacent to the Waifakaio has approached us in order to see if we're ready to take Esplanade Reserve on his property. So we enter into negotiations in a voluntary basis under that mechanism. As yet, I haven't been involved in any designations. My preference, or our preference at council, has been in the majority of instances to try and achieve these through a positive interaction with the community and over time. So that's the important thing, is opportunities arise on a weekly basis, and these provide us the ability to then enter into negotiations, and we have budgets available to us to enable us to do that over time approach. Yeah.
So I guess I'm seeing a bit of a parallel here between the covenant and QET trust process for SNAs being voluntary, and the establishment of Esplanades that contribute to PACs on a voluntary basis, both outside of the district plan.
Yes, that's correct. And I guess there would be a scenario potentially towards the end of a time frame where you might end up with a small gap or a couple of gaps where, if you can't achieve through negotiation the achievement of the vision, then you might start to look at more statutory designation type opportunities, but that's the last resort type thing.
So aside from the intervention approach with designation and the voluntary approach through Esplanade Reserves, I'm guessing that the main mechanism for taking land that contribute to public access corridors is through the subdivision process. That's correct. Yes. Okay. And so when a subdivision comes in, is there a master plan, a network plan, which helps consent planners and the council understand the importance of a particular property to filling in gaps within the network?
Through the Commission, at the moment, the mapping that we have is fairly high level. The PACs and the proposed PACs are actually the main mapping that we have to identify those. We have started to do some more detailed ground truthing and mapping for example, the Waikaio corridor. Yes. Work in progress. What the current mechanism is that the planning teams told that all subdivisions that might be occurring along particular corridors that have been identified as strategically important come through our planning team, and we obviously have the more detailed information that we can then feed into those subdivision applications.
Okay, the reason I asked that was in a previous hearing in relation to designations, we heard from Council Officer Mr Stuart Narston about the cycling and walking network that was in place throughout the district, and I was just wondering whether there was a similar mapped network for these public access corridors.
Through the Commission, yes, there is. The public access corridors are mapped, and in the proposed district plan there's a layer which maps them clearly as a green dotted line, and then there's I guess an internal, more detailed level of ground truthing mapping that's starting to occur for different ones as well.
Okay, thank you. Ms Young, these public access provisions, did they have legal effect at time of notification, or were they delayed like some other provisions? Do they fall into the same category as the SNAs?
No, they don't, because they don't have. Otherwise, I would have. Is that right, Sarah? They don't have because they don't have a little mark on the.
Yes.
Yeah.
Okay.
They're not protecting a natural resource.
No,
So,
but the policies that relate to public access corridors have effect and can be weighed.
but not the rules.
Yes.
Yeah.
Have you had an opportunity to discuss with the consenting staff how those policies are sort of landing and over the last 18 months to 2 years?
I talked to them about how the Esplanade waivers were working, and I've outlined that in my Waterbodies chapter.
Okay.
And I went into quite some detail, and they explained that they are working quite well, and that they have a process for considering waiving, and that relates a little bit to my recommendation not to put in a specific policy.
Yes.
To restrict access. I feel that sort of three matters really, that the ability to waive is, so particularly the concerns raised by iwi around restricting access to wāhi tapu. So that's a reason not to take or to vary the strip in the first place. And then the other one was the just sort of what Renee was talking about around how the council's preference is to work with landowners, and so so the packs represent as Ms Davies was saying, a very high level sort of indicative. They're quite like indicative roads, and then when they are being formed, there's a lot of consultation both with iwi and landowners. So I think that there's opportunities there to also try and make sure that the formed route can avoid any sort of adverse effects on SASM sites.
Okay. My final question is, I see that you've recommended not to include the White Cliffs Walkway. What will that mean in terms of, will that create a gap at all? I mean, will that fetter the ability of the council to put in measures to enhance that linkage?
I think that's an operational question. I think I'm going to ask Renee to answer that.
Through the Commission, I gave quite a lot of consideration. I've read the submissions in relation to White Cliffs. Obviously, it's a tricky one because it has been a connection in the past. The scenario currently is incredibly complex up there. It's through an outstanding natural landscape, number one, and then the coastal erosion that has occurred has created quite a complex situation with regards to private property, relationship with the dock run track, and with the packs, the approach we've taken with all the other packs is that we've provided, identified those that we know at a strategic level are likely to be able to be achieved over time. With the White Cliffs Walkway, currently, I'm not sure that we even know that the full connection is possible. Okay. And so
for physical
reasons, and potential impacts of resolving that on the outstanding landscape. So for that reason, we felt it was preemptive to include that at this stage. What it means long term is there's still an item in the council budget, albeit down the track, to look at the situation and to understand it more fully, and if through that process there's an opportunity to achieve it, there are other mechanisms that I've outlined earlier that we can take to try and achieve that outcome.
And if there was agreement, they could be codified in the plan through either designation or through changes to the planning maps at the appropriate time.
That's correct.
Yes. Okay. No, I understand that. Thank you. Thank you for your answers.
Commissioner Littlejohn.
Thank you. Thank you, sir, and thank you, Ms Young and Ms Davies, for your reports. I'm going to follow on from the last question because it was the one thing, Ms Davies, in your evidence that sort of stood out for me. Paragraph 7.35 of your evidence, it's there that you distinguish the feasibility of the White Cliffs walkway from all of the other packs. And I think the answer you gave to Commissioner McMahon is the answer I suspected, and it is a consequence of a potential physical barrier rather than a sort of a legal barrier. And I guess that leads me to the question that of all the other PACs that have been identified, presumably none of them face the same sort of potential physical hurdles that the White Cliffs walkway does. Can you just confirm that?
Through the Commission, I'm taking advice from some of the reports I've read from experts on coastal erosion and engineers that have done some very preliminary looking at it. That's correct. It's is quite a complex situation with the coastal erosion that is still eroding as we speak, and we have yet to undertake any full understanding of what that will mean in the long term. And also it affects the tunnel, the stock tunnel, and there's quite a lot of complexity around understanding public safety and the work required to make that publicly safe as well. There is potential for a walkway and public access to be provided to the area, as there is currently. There is an access point for part of it, but it may not be that it's the entire link that's possible, and that still needs to be explored. And so I guess I didn't want to put the expectation in the that it is likely, because it may not.
Okay.
And also when we're looking at the numbers of users as opposed to the potential cost benefit of undertaking the type of work that might be needed to open up that access, there's quite a bit of work required in that space.
Okay.
Yeah.
So coming back to the other aspect of the question, none of the other PACs that have identified in the proposed district plan face the same degree of physical uncertainty. Is that your understanding?
Through the Commission, I'd probably need to have a look at that in more detail and come back in my right of reply, just to be robust in my answer, but not that same level of dramatic erosive potential, right, I guess. But I'd probably like to be able to come back to you on that once I've had a chance to have a look in a bit more detail.
Well, I would appreciate it, because you really have singled out, and I'm saying it's from where I sit at the moment, it's a pretty valid reason not to build up people's hopes if it's just not physically possible. But I'm just keen to make sure that if we're going to be applying that sort of rationale for excluding something, that other PACs have not been included that are also that pie in the sky, if I can put it like that. Just it's all about expectation management, because obviously these sort of indications in a plan can change people's view of the world. So I'd be grateful if you could just have a bit of a think about that and see if there are any others that might fall into the same sort of category. Okay. Ms. Young, the other matter I wanted to talk to you about is well, there's two really. One is this chapter, as well as the Waterbodies chapter, uses the policies as matters of discretion. So again, I'd be keen for you in your right of reply just to have a think about the issues that might arise with the drafting around that. So that's just really a bit of homework rather than a question. It's just something that I picked up there.
Yep.
And then I guess the other one is probably a little bit more fundamental, and it comes down to the usability of this overlay. And it comes from two things. One, we've defined these things as public access corridors, which give the implication that there's a defined sort of pathway. And when we've structured all of the rules up, you've talked about activities within a public access corridor. But when I go to the planning maps, I don't actually see a corridor. I just see a dashed line. And the plan user in me is looking at that and say, well, how do I know if I'm within it or not? And I mean, for some of them, and I'm looking at the one in particular that I think we've got submissions on, the one on the other side of the Huatoki, I think, where you could look at it and there's a dotted green line that sits back probably, I think, at about 20 meters from the bank of the river. And I could feasibly look at that and say, okay, well, the within bit is the boundary of the dotted line and the bank of the river. So that's where my within is, because it creates a corridor. But then when I go and look at the Taranaki Traverse PACs, there's no way of knowing whether you're within it or not. It's just a dashed line. So I just wanted to get your view on whether this overlay is actually going to be functional by reference to the way the rules have been crafted.
That's something I have considered, and I'd like to spend a little bit more time in the writer reply. So there are a number of talk to our GIS person as to whether there's a possibility of signalling that in the E-plan itself. So when you, as you're quite right, when you're actually in the pack, it comes up and it tells you that your property, there is a public access corridor. There is a potential, and it's something that I want to confirm with our E-plan provider and our GIS analyst, where there could be a note, and the note could say you need to check with the council as to the location of the pack and whether it's been formed. So that was, and I have put a note. That was sort of an idea that we had when this issue did come up through submissions. It was brought up by federated farmers. They were quite concerned. Not only you brought up the issue around if I was a landowner, how would I know? And also they were concerned about people looking at them on the PDP and thinking there was already formed legal access. So it's an issue that I think I agree we need to do further work on. And I was just wondering whether I could have a bit more time to talk to ICIVIS and our GIS analyst to see if there's something in the plan that could sort of signal that you need to contact the council.
Well, I mean, I guess the answer to my question is that as of today, we don't really have an answer for this. So I think it is something that you need to do a bit of work on.
Yeah.
I mean, I must say, and I sort of signalled it yesterday with some of the questions to Ms. Macbeth. I mean, I have and it's probably the lawyer in me, I have a distaste for permitted activity rules that require you to go and ask the council whether or not the rule applies, because that's just not lawful. So having a note which says go and ask the council if you're within or not, I don't think it solves the problem. But I think there is a problem there, particularly if you're going to use the phrase within. I did think you could potentially solve the issue around what it means if it's formed or not formed by simply adding, to example, for the permitted activity rules, you could make the distinction that there are two forms of public access corridor. There are public access corridors which are legally available for public access and formed, and then a certain set of rules apply to them. And then you have indicative public access corridors where things like setbacks and the like would apply from. But that might be out of scope. So it was just me trying to think of an elegant way to solve it without getting too complicated. But I think the within does need a little bit of thinking, particularly if a landowner is going to know whether or not they can do something within it. You need to know where the within is. So look, I just raise it as an issue of usability, and it's something I think we're going to have to try and solve so that it works properly. But that was, I think that were those were the two sort of main matters, Stephen, that I wanted to raise at the outset.
Great, and I think it's certainly while we're raising these big picture issues at the start to give you some much thinking time as you can. As you say, you've already thought about it, but Commissioner Littlejohn's right. These indicative lines on planning maps have run foul of the courts many times. You know, in the old days, councils used to put sort of dotted lines where new roading designations were going to go, and that was very unclear for plan users. They weren't designations. So, yeah, it's just that certainty matter. So thank you, Kit. Antoine, do you have any questions?
I just had one, perhaps Mr. Littlejohn's actually asked the question about the maps, but the comment I was going to make was I'm quite familiar with the way in which esplanade reserves and other types of accesses along coastal areas and river margins are done in a number of district plans around the country, and they clearly show what Mr. Littlejohn has shown, where there's a legal definition of where those corridors are, because there's arrangements for those, but then there's also the indicative line, which is similar to the line that you've used in different forms. Sometimes it's yellow, sometimes it's red, depending on whether people are colourblind or not, and the amount of certainty. So that was just a question mark whether the dotted line was the most appropriate to cover all of the different scenarios. So, and I think Mr. Littlejohn's articulated that better than I could. That was a question that I had about what's the way in which it's done rather than the what.
Yeah, I did look at, in my report, I did look at other, how lines were shown on other plans, and I looked at other plans, and they do have like a different colour for a preferred esplanade strip, so ones that haven't been taken. And I did wonder how do they update that? So when it's taken, how do they keep, I think the issue with the two sets is it happens sort of on, as Miss Davies says, on a sort of monthly or daily basis, where they are being formed. So I mean, just one of the issues is if you have these two ones that's been formed and then the indicative ones, how do you keep the plan up to date for the landowner as well? And
I think that's a valid question that you should have in your mind when you're considering these things. And I was just wondering whether, I suppose, because we're looking at more globally at this issue, is those things that should be in the plan and those things that should not be in the plan. And obviously, those things that have much more certainty and are very useful in terms of implementing the plan should be in the plan, and those things which change, which may not be that useful. Perhaps there's an argument to say that they shouldn't be in the plan, but they should be in something that's also can be updated and is useful to its users. So that was the comment I wanted to make. The other one was just wanted to just get better understanding. This is a clarification question around the use of the term Māori vis-a-vis the use of the term tangata whenua, and you've responded, seems specifically to a number of the submissions from the iwi groups, iwi submissions, which are looking for recognition of values and interests in particular areas, and you can see those track changes. But there was a couple of matters which you've touched on earlier in regards to sites of significance to Māori, that you wanted to use the terminology, particularly the phrase Māori, to be consistent with that. And I just wanted to clarify that's the intention you've had.
Yeah, it's the intention to show that's the term that's used. So it's they're called SASM sites. So yes. It was consistent sort of use of that term so they are sites significant to Māori. They're not sites significant to tangata whenua. That's just the terminology that's used throughout the plan.
Yeah, and I suppose one of the consequences of that in this particular section is you have objectives, policies and rules which in some instances mention tangata whenua, in some instances mention Māori. So there's the consistency with the legislation, but then there's an inconsistency with that particular part of the plan using different terms. And I had a question mark, does that create confusion when we're talking about tangata whenua, but for the purposes of consistency with the legislation, you're using the term Māori? And
is that something I can come back to in my
and we're going to be hearing submissions, and that's going to be one of the questions going to be asked. It's probably one of the minor matters, but it's just in terms of consistency, it would be good to get some feedback from tangata whenua groups. Thanks.
Thank you. I have a few general questions. So the first one was your paragraph 75, Ms. Young, about the fact that people with packs on them weren't notified. Has there been much criticism of that through the submissions?
There were, I think in terms of the submissions, there were 2 individuals and one individual had a pack, but she had been involved in the previous, council have been in discussions with her for a long time around that. The issue, I checked it, like I asked, I wasn't working for the council when the letters were sent out, so I did check whether, I think the issue was the letters were around, and again it relates back to that certainty, because the packs, some of the packs hadn't been formed. It would be difficult to determine which landowners would be affected. So that was the rationale, but we haven't received a lot of submissions on from individuals.
Do you think there's any risk that people would have been blissfully unaware?
I might ask Renee, what's your opinion on that?
Through the Commission, I guess the majority of, if not all the packs, are along stream corridors or along the coastal environment, in which case there is that sort of coverage under the notion of Esplanade Reserve and Esplanade Strip. So it's not an unknown factor for anyone that's going to develop, I guess, their land. And because the intention of the pack is not to necessarily progress unless opportunity arises or there's an agreed negotiation, I think there's a process going forward that will enable us to engage really comprehensively with private landowners in what I would imagine a more positive way than if it was a designation. So although there may not have been letters going out and people may not be aware, I think the process that we would undertake would be a consultative one. So I don't know if that answers very clearly, but...
don't think it directly answers the question. I would like some advice about what's your opinion about whether, because there are rules, policies and rules that are applying to private land here. Look, more of a comment, like I see the council has quite a, or is this fair that the council is quite ambitious about its future off-road, walking, cycling plans for the future for its community? It seems to be, from what I've read, is quite a key part of the council's future planning. Is that right?
Very much so, and backed up by the majority of the community through mechanisms other than the district plan, such as the long-term plan, where the majority of submitters were fully supportive of the current proposals for extending our tracks and trails, but also in fact wanted more, some submitters.
But it seems to be that this is a attribute for New Plymouth District that you're looking to make something, it's I know personally, Taranaki is known for its amazing walking opportunities. So the council, as a key policy position as LTP and its funding provision, is really getting behind that. That's how I read it. Is that right?
Definitely, yes.
Yes.
Yep.
So have you, in terms of background, the Waka Kotahi and the government has a national, can't never remember the name, it's a policy statement around transport, and it's updated by each government, and that is very, very strong on multimodal transport opportunities. So have you thought about that in terms of, underpinning the whole approach and, the whole funding issues, how if designations are required, like the Taranaki Traverse looks like an amazing opportunity, but it's still a work in progress. But it does, in my mind, in the big picture, this whole focus does seem to be pretty much in tune with national, local expectations and those high-level policies from government.
Yep, through the Commission, yes, the walking and cycling strategy and the national waka kotahi strategies around that basically underpin what we're doing. The budget lines for our Tracks and Trails project are through the transportation team because there is the opportunity for to access waka kotahi funding in regards to some of these, particularly some of the connections along the stream corridors that might contribute to commuter accessibility and the Waitara to Bell Block walkway, for example, connecting townships is one that's definitely looking to get waka kotahi funding. So that is embedded in the planning for all of these and the potential for multimodal, so shared pathway, or depending on environmental conditions, we may need to split cycling and walking. Particularly, for example, along the Waiwakaio corridor, it's a little bit different than the coastal walkway in terms of the types of environments that you are going through, and it may be one example where we might split the modes for certain more sensitive areas, for example, and that's all work that's still to be ground truthed and worked through with iwi and hapu as well, but definitely that's wrapped into the whole strategy and plan for these corridors.
Yes, and I've been privileged to be taken on a walk up the Huatoki River by some of our iwi, some of the iwi people around about New Plymouth, so having those urban accessibility amongst some of these pretty incredible waterways, they have changed, but there's still a lot of history there. So I think just in the big picture, I can see what the council's trying to do. I do have a specific question which I'd like you to think about, and it will come up in the iwi submissions as well. It's paragraph 117 of your evidence, Denise. It's just this, you're changing the wording around engagement of the expertise of tangata whenua, and I just have it. It's quite an important. It's the term engagement off rather than engaging with. Engagement off, to my mind, as a consultant, is you're paying someone to be involved, and that's not necessarily always the case, but sometimes it's quite important. So I just wanted to know your the way you read that. Is that another word of saying consult with, or is that engaging as in engaging expertise and paying for expertise?
I think it came through a consequential amendment as well, and it is around that wanting to recognise that, iwi and hapu are experts just like other experts, like you pay for an engineer, and yet there has been iwi and hapu, there's that expectation that they give their expertise with no sort of, not really, payment. So I suppose I think it is quite an intentional change.
Yes.
And it's something that has come through the submissions, especially from Te Atiawa, about just recognising that they hold this intellectual property quite similar to how I do as a planner and how engineers, and just recognising their expertise.
Sure. And that's certainly from the way I perceive that expertise. It is expertise is required under the Act to investigate these expert matters. I just want to clarify that was intentional. I'm making a judgment at all, but just wanted to double check that was the
Yeah, it was
the intention.
It was intentional.
Intentional. Thank you. Look, one other question, and it is about the White Cliffs Walkway. Again, I was very privileged to be able to. Well, I sat on the Mount Messenger hearing as the hearing commissioner, and actually had quite a detailed look all through that area by helicopter, including the Stock Tunnel, which is just quite an incredible feature. Hugely historical and quite unique. But my understanding is that it's also, apart from the erosion issues, there is some of the landowners there are very opposed to having public access through their land, and that is that as important as the erosion matter, or is the erosion matter the main reason why the council would not pursue that as a future walkway?
Through the Commission, it's one of the additional reasons that there's complexity to this issue. That's probably the least, the erosion issues are the aspects that will create the most cost in potentially resolving the issue. But the legality and difficulty around the private land and the current view of the landowners around this whole situation is going to add a lot of legal complexity as well.
It's a factor.
And it is definitely a factor. There's been no current re-engagement with the landowners through the proposed district plan for any PAC in that location. Okay. So that's another thing to consider.
But my understanding from listening to evidence in that process, that I think you mentioned that there are perhaps not a full walkway opportunity, but certainly different ways of getting into that area, and may not be a loop, but yes, there's different opportunities. Is that right? Because some of the land is Ngāti Tama, some of it is Department of Conservation. Yes.
That's correct. Sort of at a very high level, there's probably roughly about 6 different options that could be explored, that go right from the full reinstating in some way the full length that was originally utilised, through to loop walks, of all of which those options have different costs and need to be explored in more detail in terms of, again, as I say, probably also looking at the cost benefit. It's a fantastic location and would be great to have walking there. But some of the numbers that we've got from the users, and past numbers, there haven't been track counts for a while, indicate that the full walk is less utilised by the full range of people. So it might be that a smaller loop track is more efficient and useful from a cost perspective for council, for the numbers of users, and all the Walkways Commission and DOC need to be a part of all of those considerations as well, and those discussions have yet to occur.
Yes.
Yeah.
Yes, and your evidence is that this time horizon, you've got LTP funding in 10 years' time. District plans under the current regime have a nominal 10-year life. So your evidence is there's a period of time up to 10 years, maybe beyond, that will take to actually organise this for the future. That's your evidence?
Through the Commission, yes, that's what's currently in the long-term plan. There's obviously opportunity for submissions to be made every 3 years,
sure.
and in fact through the annual plan process, but mostly through the 3-year updates to bring forward those planning considerations, and that may happen. And also there's opportunity for situations to change, which might trigger the situation I discussed earlier, where we might look at other mechanisms. Yeah.
Okay, thank you very much. And thank you both for your assistance. It is much appreciated, and there's a bit of more thinking to do, and certainly hopefully you'll be here listening into the evidence. So we'll see how that goes. So thank you very much. All right. So for those that have arrived for the 9 o'clock start, I just want to explain that we had quite a busy day yesterday, and we didn't quite get through the staff reports. So we started at 8:30 this morning, and that's why you've walked in and we're already in hearing. So I do want to just, for those that weren't here yesterday, I just want to give a brief introduction and a welcome to all of the submitters. My name is Stephen Daish. I'm the chair of the hearings panel. Commissioner David McMahon on my right, Commissioner Antoine Coffin on my left, and on the screen all the way from Auckland, Commissioner Kit Littlejohn. Just to confirm that we have been appointed by New Plymouth District Council to hear and make recommendations on the full district plan. We're hearing those the hearings by topic. I think there's 23 hearings planned over a bit over a year's period, and we'll be making our recommendations all at the end. So we'll hear, because there's quite a lot of interaction between the various chapters. Probably the other things to note is, I wonder, Julie, it'd be wise to just do a quick health and safety for those that haven't been here before.
Thank you. So just we'll do the mundane stuff first. So the toilets are through the seated dining area to your right, or there's some straight down the corridor as you came in. In terms of evacuation, if the fire alarm goes, the meeting point is out in the main car park, so through the main entrance if you can. If there's an earthquake, drop cover and hold as best as you can, and then we will await further instruction from the Devon staff. Tea and coffee machines are out in the foyer there, so help yourself as you need them. There's a water cooler at the back of the room if you would like some water. In terms of COVID protocols, so you'll see we have the chairs spaced for social distancing. Please wear your masks when you're moving around, coming into the room and leaving the room. But while you're seated or while you're presenting to the commissioners, you're welcome to take your mask off if you feel comfortable doing so.
And for those of you that haven't appeared like this before, we try and keep things as informal as possible. So we're really, really interested in what you have to say. We're here to literally hear what you have to say, and we'll do that carefully and respectfully. And if you need to ask for a bit of time to just get yourself settled and things, that's all fine. So we'll just play things pretty quietly. The order of hearings we'll get through today, there may be some delays, we may go faster. It's just one of those matters, so if you could just bear with us on that. So with that, I think we'll just get going with our next.
Commissioner, we should just mention that the hearing is being recorded.
Oh yes. So the hearing is recorded on the Zoom platform. It's really useful for two things. People, particularly those submitters that currently can't be in person, can listen in and hear the whole hearing and be available for questioning. The other thing, it provides an important record for the panel, both a verbal record and a visual record of questions and answers. So just to let everyone know that the recording is happening and is available to us. Thank you very much. All right. Stephen and Carla Houghton, you here? Can you just come forward?
Good morning.
Morning.
I'm Stephen. Apologies for my wife. She's stuck at work at the moment. Things going on there that she couldn't be here today.
All good. And you have Stefan with you?
Yeah, Stefan is here to help me with some things, so he's going to have a little bit of chat about the technical side of one of my topics. Yep.
Yes.
On SNAs. So,
Yes.
Yeah.
So the floor is yours, so just however you want to start, and we'll... Yes.
Okay, thank you. I've got a few areas to cover on SNA that affects us, so I'll try and be quick as I can about it. So from me as a landowner, I've in the last 5-6 years I've purchased a few blocks of land for different reasons. During that process, had no idea about SNA. Literally only probably had my first proper formal contact was for this one on my Kaipikiri Hill block. First time I'd ever really had anybody official come and see me. I had heard some rumours, but that was about it. I've got a unique bit of land up there. It is very special. I'm not going to deny that 100%. Got a huge amount of respect for it. That's why I bought it. And our goal was to stop development on it. And that's what I'm still planning to do. But over the last couple of years, there's been some, through the district plans, there's been applications on that plot for a different bunch of reasons, and that's what I'm here for about now. But we'll just concentrate on SNA. I can't deny that bit of bush that is on there is truly awesome, 100%. So that is a definition of what I'm not too sure what SNA, or what is significant. It's my definition of it. I believe it is old, truly native, and it's awesome. Hard topographically to get through, but my goal was always to try and put in some walkways through it so we can enjoy it and get access to the bottom, to the creeks, and part of the old farming way was a couple of springs in there just off to the edge. Now, because I bought it, when I say old springs and waterways that used to be used for water for the animals, is now come back into being needed. And I took the lady who came in, with me. I think you might remember I showed you where those were, because the access that comes from the modern way of doing it on the farm that it was joined to before is gone. So I really want to, on that piece of land, want to make sure I've got that sorted before all this happens. Hopefully that was the idea. I got the impression that they recognised there were certain areas where a track went through it already that had been there forever, and so I'm not too sure how that's going on that one. And as for the rest of the land, it was about just building a couple of homes for how my family for the last 100 and something years that we've been here have lived with grandparents and their siblings. So, but I think that's really too big. I mean, you'll probably talk about that a little bit, won't you? Yep. Other things in that area are I have an issue with what is deemed significant. I do not believe in any way, shape or form that there's a large amount of things like manuka, kānuka and pungas that should fit into this criteria around these boundaries that have just been drawn around land. I have another particular block of land that's just over 300 hectares in size, and of that, for the last 20, nearly say 30 years, about 80 hectares of that has been used for forestry. Prior to that, there was an area mass a lot bigger than that that was used for farming. And because of forestry nature, they've gone out to the edges and allowed part of the old bits that we used to have stock and stuff on it before to go back into regrowth around, and it is very clear that it is just regrowth of manuka and the pungas. So from a business point of view and a modelling of farming and what land's used for, as times change, I think there's an issue there where we've got to look at the future and how the economy's changed and people look at what they do with the land and to make an income off it. I think we've got a big issue with that at the moment with a lot of current landowners as they've gone through generations change. I spend a lot of time talking to younger generations. I'm quite a businessman in the background for a whole lot of reasons. And, they're frustrated. They've got their hearts and their souls are around environmental and taking care of it is in the right place, but they look back and what Dad has done and choices he's made is probably not the smartest ones in today's world, and being able to utilise that land for proteins or whether it's honey or bees or anything like that has now become, no one knows what to do. That's what I'm finding. I don't know what to do, where to go, and it's just stalling everything around progress in those places. ETS is another issue around some of the stuff that needs to be addressed. I think that's just criminal what's happening there, where we have these potential sources of income that make our worlds all able to run economically a little bit better, but don't have access to it, where I'm sure the government does. That's potentially on one of my blocks of land's a big issue.
So what's the issue there for you, just specifically, on your block of land?
Around the Manuka?
Yes.
So, at the moment, under the emissions trading scheme, there is an opportunity for that to be used as carbon.
Sure, understand, yeah.
And by definition, that someone comes up with what is planted or not planted or regrowth, all that sort of stuff. It's doesn't matter whether it was planted on 1989 as a pine tree, post or pre. It's still in the ground. It's still doing the job. Yet some farmers, some trees, whether it's a tree or a manuka, one day they have a right to claim. The other day they don't.
Yes, so it's the date issues that you're talking about.
But that all now those assets fall into this SNA world where it's taken completely away from it. I also believe that the age of someone could correct me if I'm wrong here. I've had a couple of answers on this. The age of Manuka, Kanuka and Pungas and around this regrowth area, around outlying areas of land that could still be used for multiple reasons in today's world and in the future, because it's always changing. That's something else that people need to think about. As I mentioned before, our generations of what they're noticing now, and I'm one of them, it's happening to me, is too young, because I've harvested a block of trees recently, around 3-4 years ago, that the farmer before me chose to not plant that bit, and yet now that we're in the world we're in today, it makes perfectly good sense for me to put pine trees in these, because it's made for it, and it's definitely not got what I define as native forest in it. When I look at it like that, yet those lines have just been arbitrarily drawn in there, and here we are trying to move on and can't progress, I guess. Sorry. This man up here, I like how he put it before, is one of my ideas is around through these consultation process and period is like, is there a way of looking at listening to people like us, understanding the arbitrary rule that have put lines and said this is it, recognising that yes, there are problems, there are gaps, everyone's got unique situations. Can we set up, can there be a way where we work knowing those things before all this goes into law or legislation, whatever it is. But then again, it comes back to going to the council through a process, which I don't think we should need to do. Some of these things should be able to
just Mr. Howden will take a pause.
Be just taken straight out.
Yeah, we just got
after some good science is put into it.
All good?
Yep.
Yep. So,
Yeah. Sorry, I think I've disappeared, but it's all right. I can yell. Okay, thank you.
That's good.
Keith, yep.
So my submission, which I assume you've all received and
Yes, thank you.
taken as read,
Thank you.
focuses really on the piece of land that Stephen and Carter have at Kaipikiri Road.
Yes.
Just wanted to acknowledge Marlene, who's here, Marlene Benson from Ngāti Mutu. Marlene, in a positive manner around getting a house site for Stephen Carter. So the land currently does not have a dwelling on it.
Yes.
I think that's a particular area of focus that technically I focused on in my submission.
Yes.
And then perhaps in the sense of looking at the consenting pathways and the precautionary approach that was talked about yesterday, widening out in terms of what are the gaps potentially that I'm seeing as a practitioner.
Yes. Look, thank you very much first for your evidence and the way you've looked at this case study and done the mapping. That's hugely helpful. And I think for us, it would be good if we could actually get the key plans up on the screen
Okay.
for you to talk us through those. So it's actually the key plans at the back of
If you go to your
Mr.
timetable
Kiss's
today and follow
evidence.
Mr. Kiss's,
This. Yeah, but we're after these plans which come out of these. But those would be helpful to talk to, wouldn't they, Mr. Kiss?
Yes.
Yes. Excellent. I think that goes a bit wider if we could see the whole. Zoom out, I think, so we can see the whole plan. Okay, and just let's bring it down a little bit if you can. Just scroll down. There we go.
Okay.
Thank you.
So just talking through this again, so the operative district plan plan maps had two Waitapu sites identified, and we've drawn a radius circle of 200 metres around those.
So that's
250 metres around those.
Orangey brown and the reddy
Yes,
colour?
and then a 50 metre buffer, and that leaves the remaining bright green coloured land as effectively the land that is under the district plan a permitted activity for locating a dwelling.
Yes.
The operative plan. And then on the second sheet,
Yes.
with the work done for the proposed district plan, Waitapu sites have extended west and encompass the predominant northern and western portions of the block. And the SNA has been introduced to cover the SNA area, and the bright green areas are now the bottom left-hand corner of the screen, and we've analysed those from a topographical point of view. We're left with about 0.5 of a hectare from 21 hectares of land that you could now locate a permitted dwelling. So in my submission, and I know that we are doing these hearings in separate portions, but really it's the overlapping constraints of the various GIS layers here that are of concern to me as a practitioner around providing a consenting pathway where there is no habitable dwelling on the site is a good test case to sort of look at how will these rules operate in practice. Because one of the frustrations for Stephen and Carla has been with the consenting environment that we've got at the moment with these rules having legal effect, and it's just really complex. And I just don't believe it should be that complex to locate a dwelling on a site. I think there's sort of some fundamentals there from a practitioner's point of view that we should be setting up a district plan that is looking at that, taking a step back and looking at that and actually enabling a pathway for these basics.
So Mr. Kiss, you've looked at the consent, the activity status of siting something within the land. It's not non-complying. Is that where you've got to?
Yes. There is a location in that green area where a house could be located. That may not be the location that Steve and Carla want to put the house.
Yes.
That's also an issue.
But you could still make an application. There is a consenting pathway, is what I'm trying to get to, as a non-complying activity. Is that right or not?
Yeah, non-complying through the gateway test. Again, a non-complying activity as a consenting pathway to me it's really difficult. It's a high bar.
Yes.
And I heard the comment yesterday from Michelle that the council does receive a lot of non-complying activities, and I do a lot of non-complying subdivision activity applications. But I can assure you, it's a heck of a lot of work. And for a dwelling, to build a house on land that doesn't have a house, should the bar be set that high? And I don't believe that it should be that high for a dwelling. Landowners who often are not familiar with the resource consent process go through a non-complying application to build a dwelling as a significant undertaking.
Sure, understand.
Oh, yeah, this issue here is like, what's it worth now? What the value of my land because of these rules is just, to me, has got to be. I don't want to think about it, to be honest. So how's that all going to work? Where does this? It's like relief in rates does not cut it, in my view.
All right. Well, I think is there anything else you would like to I think just in terms of your presentation, before we go to questions, was there anything else you'd like to highlight, Mr. Kiss, with your evidence?
There was just one more thing that I wanted to comment on, which is regard to the QE2, the subdivision provisions which talk about the QE2 or moving towards a covenant. I've got a lot of experience with subdivisions that have led to covenants, or put another way, where the landowner has worked its way through QE2 and presented to council a subdivision proposal that includes a QE2 covenant as part of the whole thing. And what we generally find is you've got the landowner engaged in a positive way with QE2, and it includes the QE2 having a whole national structure and funding associated with it. So the landowner feels supported. In my opinion, the QE2 process is a really good end game or a really good end goal for a lot of these SMAs.
Yep. And
if we can provide a consenting pathway that triggers landowners to engage with QE2, that's a good thing.
I'd like to agree with that because one of the ways I found out about this unofficially is that I used to do a lot of triathlons with Neil Phillips from QE2, and he was a good friend of mine. And when I saw this, I got him up to have a look at this to ask him about it. That's when he says, "Oh, you know that's under SNA." I go, "What the hell's SNA?" So then I took him and showed him all my other places, and he told me all about it all. And I thought, well, this fits with my own ethos around looking after it anyway. So, and when I listened to that process, I thought, well, that's a lot more palatable than this, And the big block of land that I've got up the Okoki, the Pico area, I mean, I could also look at that in the same view if I can get the land that should have been still in farm or into trees back out. So it seems to be, at least that way, I know what I'm trying to deal with at the moment. Don't know.
So your other block, has that got an SNA on it as well?
I believe so.
Okay.
I've never had anyone. Neil told me that a couple of years ago, so you
haven't checked the planning maps to see whether
I'm fairly certain it'll be still there the way it was before.
It was on the original plan.
Yeah.
Okay. Yeah. All right.
Sorry, just to finish on that.
Of course.
So If the suite of rules in the district plan that protect SNA is at a higher threshold than QE2 apply for protection, then I don't believe we're encouraging towards the SNA, towards QE2 protection. If the rules provide consenting pathways and the triggers are less than the stringent requirements of the QE2, then you're moving towards that QE2 covenant in a positive way. Does that make sense?
Yes, it does. Have you actually provided some suggested rules? I'm looking at your...
Not for the subdivision provisions.
Okay.
QE2, no.
Right. There was a request that where you were looking for changes to the rules over and above what the staff had got to, that we received suggested rules that were within scope. So maybe that's something, we'd certainly like to receive that, and I could give you some time to do that and come back to us, because I think that would round out the submission. Oh, there are rules there. I couldn't see those. Are those? Oh, all right. So you have done that. Page 10. Look, I have read that.
10 and 11.
So you have provided the rule framework. Sorry about that. Yes. Okay. Is there anything else either you'd like to give us before we go to questions?
Talk about forestry or not?
Probably leave it.
Okay. No,
Okay.
I'll leave it at that. Thank you.
Thank you very much.
Thank you
Mr.
for listening,
Houghton. We do have some questions.
Yes.
Possibly. So, Commissioner McMahon.
Yep, thank you, sir. Good morning, Mr. Houghton, Mr. Kiss. Really good to have the visuals in front of us and the juxtaposition of all of the overlays and how they affect a particular property. It's a real and timely reminder of the effect of these rules. So thank you in particular, Mr. Kiss, for putting those together. Before I go to questions, though, can I just get some clarification about that image? The bright green area. That's an area that's clear of any setback from buffers from the two wahitapu and any SNA, is that correct?
Correct.
Yes. So what's the activity status of a dwelling on that bright green area?
Permitted.
Okay.
Topographically,
That was my next. Look, just bear with me, Mr. Houghton, I'll come to that. There's a process here. A dwelling could be established as of right there, subject to meeting whatever the normal standards are for dwellings in presumably is that rural productive land or? Yes, yeah. Okay. So then the next consideration is the suitability of that land for foundations, the topography, the what vehicle access would be necessary. You're a surveyor, Mr. Kiss?
Yes.
Yeah. Are you able to talk to those two issues?
Yes. So the eastern side of the road, the slope, the topography is not really suitable. It's heading down towards into the gully of the native bush there. The western side, the north and western side of that blue area is steep.
The turquoise area?
Yeah, west of that. So it's really just the southern tip of the green area.
So what's the main road? I mean, I'm not a local. I don't know the area very well. So,
Yes.
I mean, where's the main road coming up to this block of land?
through the middle of.
Yeah, the block is split into two by Kaipakuri Road.
Okay.
You can sort of see it snaking in and around
Yes.
through the centre there.
Yeah. So it goes through the turquoise and the red. Yes. Okay. 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 So what you're telling me is that you could establish a dwelling as of right, but it wouldn't have necessary good foundations, it wouldn't have good aspect, and it would be challenges in getting access to it.
Yeah, and it's also positional. There's also some other neighbours up in that area as well, that proximity of other houses and so forth.
What's the issue there?
It's not really a resource consenting issue. It's really more where Mr. Houghton would like to locate his house.
Right.
To provide amenity to his family.
Yes.
Yeah.
So that leads me nicely onto my question. Where is the ideal location in this block for a dwelling? Mr. Houghton? where would you like to put your dwelling on this block?
The two we originally were starting with is one is at the
You're welcome to go up and just point it out to us if you'd like to.
in the red.
In the red,
one,
yeah.
Yes.
And the other one is in the brown.
Okay.
Yeah.
Right.
They were our ideal places. Yes. Yep. For a whole bunch of reasons.
Okay. Just remind me, Mr. Kiss, what's the red? That's the buffer, is it?
The red is the sort of pinky scarlet
Yeah.
red is purely Waitapu.
Yes. Oh, it's actual. Yes.
Site of significance to Māori.
Brown is
Sasam.
a second Sasam site.
Right. Okay.
There are two sites.
And the turquoise is the buffer emanating from those two
Correct.
sites. Right. Okay. Because so in the brown, the activity status would be non-complying for a dwelling, being
It's either fully discretionary or non-compliant.
for an SNA.
In the brown, it's a Sasam.
Yes. And okay. And the activity status.
I'm fairly sure it's discretionary.
Okay. But we know that in the SNA, it's definitely a non-complying activity. Okay. Okay, just while Ms Macbeth's looking, are you able to clarify the activity status for the SASM?
I can look that up.
Yep, that'd be good. So you've both indicated that you've been working through with iwi as to a possible house site. How's that progressing?
Quite well.
Good.
I think it's fair to say that the provision, the objectives and policies of the proposed district plan, because they're so fresh and new, the relationships that we have with iwi are becoming more. We're getting to know each other better.
Yes.
And so these relationships are building.
Yes.
And I think we're looking for positive outcomes.
Yes. Do you think you'll reach a stage where you can progress to lodging a resource consent?
Yes, we have lodged a resource.
Oh, you have?
And the engagement continues. I think
Yes.
we're into the fine detail.
Okay. And just out of interest, what's been the time frame for that? When was the consent lodged?
Years ago?
Sorry?
4 years ago.
4 years ago, so prior to the plan being notified? Yes, okay. And, well, the application's still on hold, I take it?
Yeah, there's been a range of changes in personnel and obviously with the proposed district plan.
Yes.
Changes in the proposal.
Yes. So where does the action lie at the moment? Is there a request for further information needed to be responded to, or an affected party approval? Or
I can tell you we have requirements to talk to Heritage New Zealand.
Yes.
And further engagement with Arlene and Ngāti Matunga.
Yes.
And one or two other things.
Yes. Okay. Okay, I'm not trying to pry unnecessarily. I just want to understand what I'm getting has been a long process.
Yes.
Been largely positive, and it looks like there might be a light at the end of the tunnel, hopefully. Is that the impression you're wanting to leave the panel with?
I think there is. The framework for discussions and sitting around the table together with iwi and with council and so forth be a great outcome of the objectives, policies and rules of the district plan overlays.
Yes, and almost worthy of a case study.
Yeah, it is. And I think the landowner feels that at this stage that we're not achieving that with the current district plan proposal.
Okay.
The landowner feels kind of hapless at times around where they sit at the table and achieving that objective of building a family home.
Yes.
Yes.
The reason I've spent a lot of time on those answers, Mr. Kiss and Mr. Houghton, is that it strikes me that there are three options here. One's to carry on with the process that you're undertaking. The other is to intervene in the rules, and that has a spectrum of removing the SNA at one end of the spectrum, through to changing the policies and objectives of rules as you've outlined in pages 10 and 11, which will have district-wide implications, not just for this SNA and SASM, but for those rules and policies would have application to all. The third option is maybe to work through the covenanting principles with the QE2 on the basis of, and I'm hoping I got this right from yesterday, Ms Macbeth, that there's a desire from the council, as I understand it, not to duplicate legal protections through covenants through an SNA process. And Ms Macbeth said that's not efficient and effective in the Section 32 sense. And in fact, in some of her recommendations where there's been covenants put in place, she's recommended removal of SNA. And in 3 cases, she's recommended where covenants might come to fruition before the district plan's finished, she's prepared to reconsider recommendations about removing SNA. So I think I got that right.
Yes, sir.
Yeah. So what I'm suggesting in terms of that third option, there's a potential opportunity to negotiate a covenant to achieve Mr Houghton's objectives of protecting the bush, which is awesome. Whether that's a criteria for identifying significance, I don't know, but it's a good term. And I'll come to you in a minute, Mr Houghton, but it just seems that I understand that the covenant system provides opportunities to negotiate the terms of reference, terms of conditions that the covenant would operate under, which might include the provision of tracks and a dwelling platform. And I just wonder whether, as a consultant, whether that's an area of advice that you might have imparted to Mr Houghton.
No, I don't think it had been clear to me that that's new to me. So thank you. That might be a pathway, because I do know that QE2 do allow, as part of their covenant, certain development like tracks.
Yeah, and it's on a case-by-case basis, I understand it. It depends on...
So I've been interpreting the rules as sitting in front of the covenant. So first of all, we've got this rules basis and covenant afterward.
Well, at the moment they do. Those rules do sit there because you've got a proposed SNA over Mr Houghton's property, but there is an ability to substitute the two, I understand. How that's achieved is obviously a timing matter, whether it's done as part of this district plan process and at the time that we make our recommendations sometime next year, or whether it's done through a plan change process and sort of a wrap up of plan changes that the council do from time to time. But there obviously is a clear intention from council to avoid that duplication. And there's not really a question there, and I guess what I'm indicating, it applies to a number of submitters that have opposed SNAs in total. Those 3 scenarios: work through the current rules, try and get a consenting pathway, change the rules that have district-wide application, or work through a covenant process and try and negotiate terms on that covenant that would allow for tracks and dwellings on a case-by-case basis. Sorry, Mr Houghton, sorry I cut you off earlier.
Just to talk a little bit more about that, that's what I was referring to before when I brought up the QE2. I had a feeling that potentially that was a way through it, and some of the work I've been doing on this in the background at the moment, again, is the only way I can feel that with some of my other land is a way I can safely build tracks and fence lines around SNAs. So another thing in forestry sector, there's a whole lot of civil rules. And we live in hard land, so to safely, whether it's that or just farming in general, access has to be considered properly now around how you do those. So I have a lot of things that are existing, or they've been there for a long time, or been developed through forestry and stuff. I have to be able to get back into those and set them up for future. And all this is just literally has stopped me for a very, very long time, and it's costing us a lot of money. it's
All I wanted to
Yeah.
point out, Mr. Howden, was that there's three ways that you might be able to
Yep.
achieve the goals that you want, and the goals that the district plan set aren't hard and fast in using regulation through the district plan. They see that there are other methods that could be used to achieve the goal of protection of Indigenous vegetation.
Yes. That's correct.
I think that's all from me, sir.
Yeah, Ms Macbeth, was there a clarification you wanted to make?
In respect of the tracks and fences and access, the rules have been drafted. We're calling them workable rules. So, and they do provide as a permitted activity to maintain access tracks. And if, say, part slipped away, you know, I believe it would be within the permitted standards to rebuild that, to ensure that access, and that would not require a consent.
Is that under the SNA or the SASM rule?
The SNA.
Yes.
So how do we get on with boundarying and stock control and fencing?
So
That doesn't have tracks.
So there are permitted standards for conservation activities, which include fencing for stock exclusion, trap lines and pest control, so you can carry out work within there.
Yeah, but that's within that conservation, that QE2.
No, within the permitted standards of the SNA rule.
Those are things you can do without consent, so that's why I thought it was important that Ms Macbeth can clarify that.
So in the world of HSE today, and the terrain that we live in and operate, and access and all those sorts of things, it's not just a matter of climbing around banging posts in anymore. You know, there is disturbances that go on along these ridge lines.
Yes.
Is that acceptable?
So the permitted standards include necessary for maintenance and repair of existing tracks and fences, drains, structures, infrastructure, necessary to remove vegetation that endangers human life or existing buildings or structures. So I think they would provide for the things that you're concerned you can't do in your SNA except for the building platform.
What about new track, a new access way to access a future dwelling? With that, presumably that wouldn't.
That would not be a permitted activity.
No.
In the SNA, and you sought clarification under the SASM rule, so that would be a discretionary activity.
Fully discretionary?
Yes.
Yes.
So if I put my other farming hat in, the way I see the world economy going and opportunities for different sorts of proteins and versatility of using land these days, because it seems to be the smart way of doing things. I have a potential block that can be used for deer farming and forestry and other stock, yet I'd have to stick in fences along boundaries that currently do not have a track on. What happens there?
So are you talking about your other block that has, and it would, so if there's no SNA?
If there's an SNA.
If there is an SNA,
yep.
So you can fence that as a permitted activity, and if you need to, you know, there's, through the QE2 process, it's interesting because they take quite a pragmatic, you know, walk the ground and see where's the suitable place to put a fence. And that would be a permitted activity if there was some clearance needed for stock exclusion or deer exclusion.
Just so I understand that we're clear, we're talking around boundaries that currently do not have fences or a track at the moment.
Could you do that without vegetation disturbance?
No.
Is there currently stock on that land?
There has been.
Yeah.
I have tried again, and there was in the past before in this particular place.
Yeah, so that the first rule, R1, allows for, as a permitted activity, vegetation disturbance or conservation activities. New fences for conservation activities. So stock exclusion would fit within that.
I think we're too much to discuss there.
Yeah, I think.
I get that.
So look, I think seems to me listening here that the door's always open at the council. It's something that I've talked about yesterday with other submitters, so there might be an offline discussion you can have. Look, I will go to Commissioner Littlejohn to see whether he has any questions, because he's waiting patiently there and may have some questions.
Where are we? Yes, thank you. Mr. Kiss, 4.2 of your evidence, you set out the submission that Mr. and Mrs. Fortin lodged. Can you confirm whether that was the only submission they made on the proposed plan?
Yes.
So they did not make a submission around the extent of the archaeological sites, the historic sites and the SASMs on the property?
Yes, they did as well.
Okay, but you just said that this was the only submission that they made.
Sorry, there's in 4.2, I've listed their submission, which is a submission in regards to the sites 433 and 603, which is the SASM site.
Oh, sorry, I didn't see the reference to SASM. So, okay, I understand that now. Okay, so you have made a submission about the extent of the SASM, and presumably you're going to be involved in that hearing as well about that?
It may be me, but Mr. Howden may have other
right.
experts.
Yes. Okay. So, all right. So that clarifies that. It seems to me though that, and Mr. Howden, you can clarify this. You don't want to disturb this parcel of bush that you've described as quite unique. So I'm struggling to reconcile the request for the removal of the SNA with your own expressed intention about this. Or are you saying that the only reason you want the SNA removed is that would enable you to build a dwelling somewhere within it?
My dilemma is that parcel of land currently as it sits in this proposal versus when I bought it has significantly reduced what I can do with it. And the overlaying aspects of the issues is where I think it's like the perfect storm of I don't like this word, but it seems that grabbing land in a way and taking control away from landowners to be able to live and live in a house and look after themselves. It's just, yeah, it's got me buggered, to be honest. That's what this is all about for me on that particular block of land. Yeah.
Well, it seems to me then that given you've already indicated your preferred locations for a dwelling on the property aren't within the SNA, then really your focus of interest, and I think you're going about it the right way, is really about the other overlays that affect the property rather than the SNA per se. But what I did want to thank you and Mr. Kiss for is that you have highlighted that in a situation where a parcel of land does not have a dwelling but is virtually fully impacted by an SNA or any other overlay, there is quite a difficult pathway through to put a dwelling there. And I mean, you're not in the situation where your whole block is SNA, and I have come across cases like that, but there isn't a pathway through the policy that would be applied in the context of a non-complying application to remove vegetation to establish a dwelling. There doesn't seem to be a pathway there that would enable that vegetation to occur where it's necessary to clear a platform for a dwelling where there is no other practicable location on the property, for example. So that's something that I've made a note of, and it's something I'm going to come back to staff on in due course, because I think there are going to be those rare cases, and if we can cater for them, then all the better. So, but all I can do is endorse where you're going in terms of your engagement with iwi on a future dwelling location. I think that's really the possible solution here for you. but I don't know anything about the resource consent application or what its status is. So, but thank you for coming along. You really have highlighted a real issue of overlaying multiple overlays on a single site. Thank you.
I didn't have any further questions, but I'll be sitting on the hearing for certain areas of significance to Māori, so I was quite interested in not only this case as a case study, but also in terms of the work you're doing in terms of the buffers and working with the iwi. So I'll be really interested in where you get to when we have that hearing. Thank you.
Thank you very much for your assistance. I would like to just reiterate those comments that we're really appreciative of you bringing this to the table, and also Mr. Kiss, the connections and your evidence between, foreshadowing the SASM issue as well. I have to say that practitioners, surveyors are the ultimate practitioner in this land development space. Actually having the ability to ask questions of an experienced surveyor is very, very good. So thank you for your evidence. Right. I think we will take one more submitted before a morning tea break. So Ray and Gloria Jupp, are you here? Thank you. So welcome to our hearing. Thank you very much for coming. And you've got some information you've just handed around.
Yes.
Thank you very much.
We've all got the same.
Yes. And so we're talking about SNAs.
Yes.
I always like to start with just like, you've actually, anticipated. What a great thing. So we can see your property there on the screen.
Yes.
Yeah. Yes. Okay, that's great. So just over to you to present to us.
Certainly. Okay, so SNA number 253, submission number 221. You have in front of you a copy of our submission dated 18th of November 2019 and what is written in council document. First part says, support in part regarding the SNA on our property not being allowed to be cleared for a dwelling. The SNA is on very steep ground, and we all know that the best thing to prevent erosion is large established trees. Second part says, we oppose council having complete control over our bush area of our property and no public access to private property. Why then in the council document does it say we have concerns? Check the meanings of these two words, oppose and concerns. They are nothing alike. When the property owner puts in their submission, who in the council has the right to change any wording to make it read more favourable for council? We say nobody. And what's more, our submission was handwritten by myself and signed by Ray, so any court of law should agree it cannot be changed without our permission or knowledge. This doesn't make the council's methods come across as very honourable. Don't you wonder how many other submissions have had their wording altered? We oppose any public access because public can cause so much damage to the undergrowth, especially on very steep ground, slipping and sliding and grabbing whatever they can to stop themselves. Not forgetting, this is private property. Council speaks of helping with pest control. In February 2015, we received a letter about Huatoki Urban Possum Control Program. We thought this was great and joined, but by December 2017, a letter from New Plymouth Urban Possum Control basically said, thank you, but it's over. Property owners are to continue on their own at their own expense. We have continued to trap the odd possum ourselves. Council also talks about assistance with weed control. We wonder what they mean, because a few years ago, we rang Council's noxious weeds department to report a large old man's beard vine across the road from us. Every year their seeds are in the millions. Not good for native bush. Yes, someone from council came and looked, but needless to say, nothing was done at all about killing the noxious vine, and it flowered and seeded again. When it started to come into flower the following year, Ray cut and poisoned the vine. And we also did 2 other big vines on our neighbour's property that we could see from the road. Throughout all these years of talk but zero action, how many young vines may now be growing down in our bush? Once again, no confidence in the council and their talk about assistance with weed control. We have a stream at the bottom of our property and have picked up and cleaned out bags of rubbish, milk bottles, plastic bags, drink bottles and cans, etc., from blown over rubbish bins, and even building plastic and rubbish washed down from Fernbrook Ave. If council has control, do you think they will be doing this? We love having native bush as the view from our windows and are passionate about the trees, the native birds that live and feed off them, and the undergrowth, which is the future bush. Sometimes after a storm, though, there may be a broken branch or a half-broken branch, a hanger, that needs attending to so as to cause at least possible damage to the undergrowth. Council thinks we should have to pay for resource consent and then pay a council-approved contractor to deal with the problem. Ray has worked with 3 different independent arborists while we had our business for 27 years on the Coromandel, pruning and felling both native and exotic trees. He has a farm safe certificate for tree work, the knowledge, the experience and the ability to do the work himself. What's more, when it's your property, you are there on the spot, can see what needs doing and can attend to it straight away. Not the case when you have to wait for consents and contractors. Does the council just want to gather revenue? We, the property owners, are more than capable of caring for our own land, and it is our right as freehold owners to look after the maintenance of our property. We are neither children nor fools. It takes years of work to pay the mortgage on a property, and although it is lovely to live in town but have the peacefulness of the bush, we would never ever have bought the property if the council had control of the bush area. Is it right the council thinks you buy the land, pay the rates on the land every year, but have no say or control over what happens on the land? It's like the land's being confiscated or stolen, but we still have to keep paying. If this happens in the future, this would totally ruin any resale value on our property, as a large percentage of it is bush. If council wants control, council should buy it. Our house was built in 1974, but the bush was here long before that, or long before any of us were born. Councillors also come and go, and the bush will still be here. We need to think wisely. Why doesn't the council choose to work alongside of property owners instead of trying to take total control? If they did, far more would be achieved. As we said in our submission, we oppose council having complete control over our bush area. While looking over the papers more closely, we discovered how council seems to change property owners' submission if they oppose. If you support or support in part, that's all good. What you have written stays. But if you oppose, your submission seems to get changed, sugar-coated, and then hidden under a new heading, in this case called Summary of Submissions and Decision Request. Our submission is extremely short, so it doesn't need summarising. Please bear with me while I explain our submission. First part, ours. Support in part SNA not cleared for dwelling. Council supports that SNA 253 should not be cleared for dwelling. The difference, we wrote support in part council right support. Second part, ours, oppose council having complete control over our bush area of our property. No public access to private property, PCNA. Council, but has concerns about who has control of the bush area on private property and public access to private property. The difference, ours is definitely opposed. Council takes their name out of it and makes us look undecided and incompetent. We find this to be insulting and a total misrepresentation of our submission. Anybody reading them would never get to see our true submission, only the council's version. How many other property owners has this been done to? Please remove our property from your list. Thank you.
Thank you very much, and thank you for taking the time to write that down so clearly. We're certainly under no illusion about what your concerns are, and so look, you've also provided a plan here with a note on it. Can you just?
Oh, we're not on internet.
Yes.
And council very kindly sent us all the pages and pages of all lots of people's submissions and things like that.
Yes.
And when we read it and we saw it, and it's like concerns, it's like, because I mean you're talking 2 years ago, and it's like we would not have written concerns.
Yes.
And so you asked them, did they still have the original copy? We had copied it, but it wasn't in my, it wasn't it wasn't a carbon copy or it was in yours. So you asked them, and yes, the council had our original, and they were marvellous. They printed it out for us, and they included this with it.
Yes.
And the note.
The note. Can you just read the note out? Because, or I can do that.
Yeah.
You read it out.
All right.
Yeah.
Rachel said to mention if it does go into the operative plan, he will be eligible for 50% rating remission on the green area.
Okay.
Because we haven't had any thing, we never put any site plan in, because we know those are the boundaries, and we know bush covers that complete area.
Yes.
And we know there's some very nice natives in there. So, I mean, we didn't need clarification of those. So therefore we have seen nobody. We didn't know about rating remission. It can also, at a first glance, look like, oh, 50% off. Well, it's not, is it? It's 50% off the green area, and all of your services run on the other part of your property, or your rubbish, what else?
All sorts.
You know, they're all in the other half. So 50% of the green area is going to be smaller than it might first appear.
Yes.
But the trees and everything that we have on them, probably it's a standard tower mainly. And they age between 300 to 400 years old. And we've got massive remus growing. I mean, and there's rivers, and the bird life is just unbelievable.
I can imagine. So
even our little wee granddaughter now, she comes in and is like, hello, Woody. And it's like, but this is all grown and survived.
And we're not there to damage it. We're there to look. We've actually planted more native trees. We've planted carries, we've planted remus, more honeysuckles, we've planted more kowais.
Yes.
You know, it's
little kneecaps. It's.
And it annoys me that all of a sudden, 7 years we've been here, the council didn't want to have a bar of us.
And to be quite honest,
they want to take over.
So then somebody walked down the footpath with a clipboard and ticked our property, and it's like, if we were being destructive.
Well, I actually asked, was everything all right? And the people said, yes, no, it's all good. Didn't know who they were. The car wasn't even labelled District Council, anything. So I thought, oh, okay, fine. And after that, next thing you know, we've got this.
We also actually have a fear of, once this is the first step, where does it stop?
Yeah.
You talk to people that live
People aren't happy.
in bush areas in Auckland and that, and they can barely pluck a leaf or sneeze in the bush without resource consent, and it becomes very, very difficult.
Look, I'll see if the commissioners have some questions.
Yeah.
Because I have, because again, look, it's awesome, fantastic that you've written it down this so clearly, and it's great to hear the council being quite cooperative. But Commissioner McMahon, do you have any questions?
Just a couple. It's clear to me, Ray and Gloria, that you really value the bush and you don't want to see it removed.
No.
And therefore, getting rid of the SNA is probably like chucking the baby out with the bathwater in that sense, isn't it?
Well,
It's more, where does it end?
Yes.
And where does the control?
Sure, and that's what I wanted to just ask you and perhaps Miss Macbeth about. It seems to me that there's a desire to enable the removal of vegetation in certain circumstances, and it may not be the exact circumstances that you've talked about removing hangers, that sort of thing. And I'm thinking, Miss Macbeth, about R1 numbers 3, which talks about permitted removal includes where it's necessary to remove vegetation that endangers human life or existing buildings or structures. Now, those hangers they may be endangering human life, but they may not do it. It's just that they, they may drop and crush undergrowth, that sort of thing. So, all I'm wondering aloud through you, Miss Macbeth, is that whether there's some ability to actually provide for those sort of circumstances in that rule, and I wonder whether you might be able to give some thought to that in your right of reply. The intention is obviously to maintain the bush and to avoid it destroying itself. And I think activities like clearing rubbish and that aren't activities that are actually prevented by the district plan. No. So, and what you're doing in terms of clearing the plastics and jetsam from that area is to be commended.
There is, when we first came, there was the native little brown trout in there, and the little freshwater crayfish. Well, I haven't seen any for a long time. We've got eels. We've actually got the kingfishers have actually come back. They
live
breeding
there.
down the bottom.
They're down there, so they must be hunting something out of the stream for them to be.
What I'm saying is I think there's a win-win situation here, and I think it possibly just needs a little bit of a tweak of the rules rather than getting rid of the SNA, and to give everyone some confidence. I'm just inviting Miss Macbeth to give some thought to that, and she'll come back to us in the right of reply.
Thank you. Commissioner Littlejohn, do you have any follow-up questions?
No, I don't. Thank you very much. It's always wonderful to live next to something as beautiful as that, so I appreciate your care for it. Thank you very much.
Thank you.
Thank you.
I just had a note here that, and I hope you tell me if I've got this wrong, that you opposed public access to private property, and perhaps I just wanted to clarify with the staff, was there any proposal for public access in this particular area? I couldn't see it. I've got these little maps in front of me, but I couldn't see this was part of those ones.
No, we've jumped in on that one.
Prevention is better than cure.
Okay.
That usually comes next, doesn't it? It's not this year's, it's in the next tweak up of the plan.
Okay, thanks for that clarification.
Yeah, so no,
we want to make sure that we've covered your original submission.
That was us jumping the gun on that one.
Thank you. I think there's a clarification from Rochelle.
I have Miss Young here who's doing the public access chapter, and she's just noted that it's the Huatoki catchment. There's already a lot of public access provided for there, and my observation would be that your land is very steep, I would say it's very unlikely that public access would be sought there.
Yeah, and I mean, that's one reason why we don't want it too, because it's like steep ground, it's pretty hard to walk on.
But having an SNA on your property doesn't mean that anybody else can come onto the land. It doesn't, it's not opening that up at all.
Not today, but what guarantee is it that in 5 years' time,
Councils
that
change.
the next step of SNAs is you're going to...
I can answer that for you. The guarantee is that there would be a public process and you'd have every opportunity to vent your opposition to that. So it's not something that happens by stealth overnight.
Thank you. That's good. Yeah.
So just one, an observation and a question. The observation about how councils need to summarise submissions. I can see the disconnect between the opposed and how that's really caused you a lot of angst and unhappiness. I think it's probably just unintentional, just knowing the people that do the summaries of submissions, they try and summarise down quite often really long submissions.
Yes, and some of them even were that we read.
Yes, so we do read the submissions and the staff are all over the submissions in terms of understanding them when they're doing the very detailed reports. So if that gives you some little comfort, I'm sure that that's just how they've summarised. The second observation I have is, Ray, you've got the tree safe background and you're obviously a very experienced woodsman. Just the ability with someone with qualifications like that without having to go to an arborist, might that be thought about, Ms Macbeth? Because I know there's, I've had a lot of tree work done on my property. It's not cheap.
No.
So is that already covered if someone's, taking a hanger out or just trimming on their own land?
The only standard within that rule that would require the council approved contractor is the trimming, the one that I've recommended through this process. So the earlier provisions, for the daylighting.
Yes.
But removal of vegetation that's endangering buildings.
Ray could do that.
Yes.
Could do that himself.
Yes.
Okay, that's good clarification.
Oh, thank you. Yeah, because by doing it myself, because I know you get a lot of arborists and they use the spikes to go up the trees, which damage the trees, and we're not having that. And the thing is, I can lower it to the ground that it's not going to crush or break the undergrowth.
Because
And
you're,
it's
you're a
left.
rigger, so you have rigging knowledge.
Yes.
On the ground, so it's not being taken away. So it's going to break down, do all what it would naturally, but it's just being done gently.
Yes, I understand. Right. Well, thank you very much for coming. This does.
As you said about like how the summary gets, the submissions get summarised, and it's like I understand that, and I can imagine some would be pages. Ours is very similar.
Yours was short.
Property.
Yes,
it is
so
just
it could have
like
been
1 or 2 sentences.
Yeah. Okay.
So it's like, why does that need to be changed? And it's kind of like, it's quite key words that are changed.
I understand.
They do portray quite a different meaning, and anybody with seeing the list of submissions does not see the word that we wrote. They see the word that's been put in there in replacement, and that did make me.
No, your point is well made. So look, it does add a lot of quality to our process to actually listen to people that come and talk to us about their submissions. Preparation has been fantastic. Your issues are well understood. Thank you very much for attending.
Thank you.
We will take a break now, checking the time. It's 10:35. If we come back at 10 to 11, so that's 10:50. Thank you very much.
Thank you for your time.
Thank you. Welcome back, everybody. I've just been advised quietly that some of the people may not be able to hear us so well at the back. Is that right? Okay, so we'll try and speak more clearly and directly into the microphones. We have Goodwin Family Trust, Peter and Joanna, is that right?
Yes, sir.
Yes.
Godwin.
Sorry, Godwin. Thank you. Sorry about that. Godwin. Right, do you have a presentation for us?
Yes, we do. Thank you.
Thank you.
So, my name is Joanna Godwin. I'm representing the Godwin Family Trust of 11 Ruru Lane, previously 484E Carrington Road. And I'm joined with my husband, Pete. We've owned the land for nearly 20 years. If we go to the next slide, please. So our presentation will be around our original submission. Very briefly, we'll talk about the officer's recommended amendments. Again, that was more pre-read, but there is one slide we want to discuss. The focus of our presentation is around the background to SNA 254, and we'll finish with our request, please.
Thank you.
Thank you. If we can go to the next slide. So, in our original submission, the land on the right-hand side is our property. The black dashed line actually shows our property. We have 2 SNAs. We have 580 on the western side, the left-hand side there, and 254 on the right-hand side. In our submission, we generally supported the inclusion of both SNAs within our property, but we did express some concerns about some of those. In particular, that we were already working through a QE2, we were concerned about fire risk, and we're concerned about footpaths, but our footpath piece we were going to discuss in the transportation submission, I think it's later this year or early next year, because we do not, like the JUP, support tracks going through the SNA. The decision's request was that the council and an ecologist would come and actually review the SNAs and remap the SNAs, which we appreciated. And on the 15th of February this year, Sarah Herbert and a team from NPDC turned up to do that exact work. Unfortunately, it was an incredibly wet day, never heard of in Taranaki, and we just let them loose on the land ourselves, so we didn't actually join them, which maybe in hindsight was a bit of a mistake, and that's why we probably find ourselves here today. I'm going to give you a heads up on what our request is, which is to move the northern end of the SNA 254, which is shown on the right there, southwards to an existing fence line. So if we can go to the...
Before we go off there, can you just, the river there, is that, can you just...
That's part of the Huatoki on the left-hand side, yes.
Okay.
Yes.
And just the size of your property? Just
17
roughly?
acres.
17 acres, thank you.
Thereabouts. That includes all the native bush.
Yes, wow.
Yeah, we bought it as a lifestyle.
It must be quite a property, it looks...
yeah, well, it comes up in a couple of the photos. So.
Yes, okay, thank you.
Yes, it's beautiful. Fabulous views of the mountain, and we're very delighted to live there. So, just going to 580, then that area is that left-hand red patch in the top photo. And that did get remapped by Sarah and the team, where they took out some of the SNA because it was pretty clear that we were already using that as pasture. We have stock on that on the farm, and we're happy with that. Just for your information, in the bottom photograph, which you can't probably see very well here, but the red ring on the photo is the SNA itself.
Yes.
In the foreground, all of that planting has been done by ourselves in the 20 years that we've been there. So we've done considerable planting on that property. And in fact, if you look at the top plot, you'll see quite a lot of other trees. That was all just an open and marked area where we've planted all sorts of stuff.
Could you just tell me what the red ring on the bottom photograph, where that is on the top photograph?
Okay. So the red ring on the bottom photograph is in the top photograph when you look in the northwest corner, just underneath the red box. It's a view looking towards the mountain, which is at the southern end of there. That makes sense.
Thank you.
And the house there is actually our house, which
That's the same one, yes.
That's correct, yes, which we built.
Mrs. Godwin, the planting you've done, is that down towards the river?
We've done some down towards the... No, not down towards the Huatoki, which is over on the right of that
It's
picture.
on the right of the picture.
Yes,
Right,
the
gotcha.
problem is the top shot
Is
is
around
looking north,
Yes.
and the bottom shot is looking south towards
Great,
the mountain.
great. Understand.
It's a bit
Gotcha.
confusing.
That's great. Thank you.
Okay. Onto the right. Okay, so the next picture shows SNA 254. It advises what was seen by the ecologist in 254. In the report, the S42A, the map that was provided is the insert in the bottom of that slide that you can see there. We requested last week the full map which showed the extent of our land. So if you look at the picture on the left-hand side, at that northern end, you can see an extension of what should be the 254 and should be coloured in red. And this is the area that we would like to talk about. The ecologist identified holly and magnolia, which we did plant, and a significant amount of woolly nightshade are present on the margins. And it's that northern end that we want to talk about, the woolly nightshade that has grown there that we've been working on, and is our suggested area for changing the boundary. That makes sense?
Yes.
Okay, so if we move to the next slide. So we've done quite some significant work down at the bottom end. So the pictures that you can see there are the pond at the bottom of SNA, at the northern end of the SNA, looking up towards the mountain. So when we first moved into the property, the first thing was to remove a lot of gorse, which we have done. And then the banks then were a bit barren, so we actually laid turf on that bank to enhance it. And we planted 6 pohutukawas along the across the top of the bank, which is in the bottom picture where you can see those people. That's where we planted those all the way up the hill.
Yes.
And more recently, then we also got a digger in to actually dig out all of the noxious weed that was in the pond at the time. More recently, we started removing all the holly and the woolly nightshade that over the years, due to probably overcommitment at work and I got really sick, we ended up leaving the land for a bit, and just recently, since I've retired, we started to remove the holly and the woolly nightshade, which I understand the council from your website and DOC website is considered as a noxious weed. If we go to the next picture, please. Next slide. So these are a series of pictures of the northern end of SNA 254. And as you can see, the grass has taken over the last 10 years. And in the top left-hand photo, we've got quite a nice green bank. And you can see the size of the pohutukawas that we planted in that photo. We've removed about 80% of the noxious weeds. And in the second photo on the top right and the next 2 photos on the bottom there, you'll see there's still quite a lot of woolly nightshade in the area and quite a lot of dead trees, which you can certainly see in the bottom right-hand photo. And there's also been some hanging trees that have fallen that we have started to take out of the area.
Yes, Ms Godwin, that photo A, is that looking north or south?
That is looking towards the mountains, so it's looking south.
Okay. So so we're seeing the end of the northern part of...
That's right, that's what it looks like. It's not native bush, it's grassy bank with a lot of woolly nightshade in which we started
looking away from the SNA rather than looking into the NSA?
Looking into the SNA.
Into it?
Yes, looking into the SNA.
Thank you.
And then if we go to the next slide, please. So our top left-hand photo, which is looking into the SNA, this is the end of the SNA, and you'll see that there is a gate there and a fence line that forms what we would call the end of the pasture land and the beginning of the native bush. And in the top right-hand photo, you can see the state of the fence line, not perfect, but you can see how the native bush looks in that area, which is the SNA. in contrast to the photo on the top left, which is the area that we think is currently in the SNA, but we don't want it to be in the SNA because it's just grassy bank, with some putukawas on there and an oak tree. And the bottom picture kind of shows again the view looking towards the mountain, so again looking in a southerly direction. And in fact, hopefully it's better in your version, but on the bottom left-hand side there, you can see a line of the woolly nightshade that we've actually taken up and stacked. We believe we've taken out about 2 tons of wood out of there to clear that area. So just as a reminder, on the bottom right-hand photograph, again, it's our property. The northern end of the 254 SNA is shown. There's a proposed general residential area in there, and the boundary of the SNA will be much clearer, I'm sure, on the version that you've got rather than on the screen, which looks a bit small from here. So if we go to the next slide, please. So our request. Firstly, we will remove the remaining 20% of the noxious weeds out of the northern end of the SNA. But we would like to see the boundary, which is now shown in red as a proposed new boundary, to be pushed to the fence line rather than kind of dotted around a whole bunch of woolly nightshade. And that's what we're requesting. We think it's approximately 30 metres from the maps, but as your maps say, quite indicative. Ours is indicative as well, so let's be clear. But what we would like is if we can do it to that fence line, which is an established fence line, that would just be the easiest way of doing it. So it obviously would include the pond, and it would retain all of that native bush on the southern side of that fence line. Okay, so if we could go to the last one. So I suppose to be clear and for the record, our submission is consistent with a submission we made in 2009 on the review of the district plan, where it was all about retaining the rural lifestyle and the rural views in the Carrington Road area. We do support the SNA. However, that is on the assumption that we retain the ownership. There is no public access to our SNA, and that we will discuss in the transport submissions, I think later this year or early next year, or the roading. Similar to the JUPS, we would like the ability to be able to remove hanging trees, and believe you me, there are a lot of hanging trees in that bush. Like Huatoki, it's incredibly steep. And our request is that we move the boundary southwards to the existing fence line. So on behalf of the Godwin Family Trust, thank you for the opportunity to be able to speak today. Thank you for reading our submission, and we are happy to answer any questions.
Thank you very much, Mr. and Mrs. Godwin. A big thank you back to you for the time you've put into that presentation. We would like a copy. So we have got them? Okay, so maybe it was in the poll yesterday, no, this morning? Okay, so look, thank you very much. We have got those. That is very clear to me. I don't have any questions, but Commissioner McMahon may.
No, surprisingly I don't. I mean, I understand exactly what you're saying, and I guess the questions that I have will be to the officers in terms of responding to the information you presented, and whether in light of the presentations they have an alteration to their recommendation.
So just following up on that, we will talk to the staff after the submissions have been heard, probably next Wednesday, and ask them to see whether they have any revisions on their recommendations, and then it will be written up in a final right of reply.
Yes, sorry. It just strikes me that I do have one question. You mentioned that on the 15th of February, a pretty inclement day in Taranaki, there was a visit by Sarah Herbert and the team. I presume there hasn't been any subsequent visits?
Not by an ecologist, but we did last week. We had 4 people from the council and 4 people from the iwi hapu who we walked around the property, but that was, I think, for looking for archaeological.
Yes.
Yeah, so we've never stopped anybody coming onto the property to hide.
The reason I asked that, I just wondered whether on a better day, do you think a visit to the property might illustrate to Sarah and the team exactly what you've portrayed in the images today? Would it be so obvious on a better day where there's not rain and mist and murk?
Well, it's always much easier on a better day, but to be fair to Sarah and the team that came, all of that woolly nightshade was clearly masking what was really on the land, and because we didn't go with them, there was no discussion.
Yeah.
So it's not about blaming anybody.
No.
We've moved all of the rubbish, and the weather was rubbish, and we didn't go with them, so it's probably a mistake.
All I'm asking is, do you think another site visit would enhance the understanding?
Absolutely. Yeah.
Thank you.
Yes.
Around about 3 o'clock when the kettle's
And scones.
Yeah, I'm sure
they always help. Thank you.
Kat, any questions?
No, that's very clear. I see there was a slight amendment proposed in Ms. Herbert's evidence, but presumably that's not sufficient in your view to properly represent the SNA.
Not sure I quite understand the question. So 580 was changed, and we were happy for that change, but with this discussion is really around SNA 254.
Ah, sorry,
Yeah.
I've
That's
got the
all right.
numbers mixed up. I understand now. Okay, no, that's good. Well, I'd support a sunny day visit so that Ms. Herbert can probably see what you've done, and I'm sure she'll reflect on that.
Thank you.
Thank you.
Commissioner Coffin.
I'm glad Mr. Littlejohn was confused and embarrassed himself before I did. I just had a clarification, just making sure I had the numbers right. So 254 is the northern part that you showed in the photos?
It's the
eastern.
It's the section on the eastern side of our land, and we are only talking about the northern part of the boundary.
In 580, you were happy with the amendments were made, and then
That's correct.
You've got another submission related to the transportation network.
Well, yes, because there are a number of proposed footpaths going around the SNAs, not within the SNAs, which we would like to contest.
And that was specific to 580, or was it to both?
Both of them.
Okay. Yeah, thank you.
Yeah. But I felt that you can correct me if I'm wrong, but we didn't think that they were related to the SNA because they actually don't go through the SNA. They go around the SNA, and it's clearly on our private land.
Just a clarification for the staff, are those PACs or these walkways and things? Can we get some clarification?
It is just an important point to note that, just to make sure you're aware that that property is currently rural production zone and been rezoned to general residential.
Okay.
So that is through a subdivision proposal that those linkages would arise.
All right. Okay.
So we can look up whether they're PACs.
But I saw on the presentation there were some dotted lines. Are those from the plan, or are those what?
They are in the plan as connections, but we can work it. We'll just look up exactly what they are.
So you'll come back to us on the right reply and just confirm that?
Yeah.
Sorry, can I ask a question, or two questions?
Of course.
One, what's a park? I'm assuming it's
Okay.
a public access way?
Public access corridor.
Right.
Yeah.
And two, am I right in thinking that we come back and then later when we talk about the roading proposed through our property, we will make another submission then?
Yes. I believe you're on the list for other chapters.
Mm-hmm.
Christine, can you?
Yes.
Yeah.
Okay, thank you.
It's just that we've been hearing about these PACs in this hearing
11 rural.
from Ms Young, so I just didn't want to, just for our own clarity, certainly if you've got a submission on the transport chapter, we will see you again. But I was interested just in the status of those dotted lines.
Yeah, that's coming.
They appear to be indicative roads within a sort of a structure plan development area.
Oh, okay.
Yes.
Is that right?
And I believe that you had Mrs. Y come out, and she's doing the structure planning for the development areas, the rezoning and.
Yes, so there are some rezoning.
Yeah, so there's a collector road, and then also a pathway connection.
All right, so that will be part of the
Indicative.
structure plan process.
So sorry.
Yes, Carrington Structure Plan Development Area.
So Louise Y did turn up the
Yes.
other day, but I thought that was under archaeology, not under structural road plan.
So the archaeology would be within the structure plan.
Right, okay.
Yes.
There are some hearings about structure plans specifically. So would that be the hearing that we might see the goblins back again?
Certainly will, because we do not support the road going through.
So
our
can I
property.
suggest you liaise with Julie and Christine just to make sure we're clear the hearings that you'll need to come to, because if you've made a submission, there definitely would be an opportunity to talk to us again.
Yes, that's exactly the map that we do not support. That's just blasting through the most beautiful and a 20-metre wide road is, in our mind, inappropriate.
Right.
Can I ask?
Yeah, you can certainly ask some more questions.
Ms. Goblin, I've just finally located your hard copy of your presentation. I knew I had it somewhere. I filed it too well. I wondered if I could give that to you, and if you could just mark the northern section for me, just so that there's no confusion.
Well, the problem is the map that's in S42A doesn't have the northern section.
No.
So I have to put it on another. So it's this area here, that area there, and we are but it's probably easy on here because that's it, and that's the red line with the approximate proposed northern boundary.
Got it.
Yeah. That's the area that we're talking about.
Thank you for that.
Okay, and then on this map, sorry, it is basically that area there.
Just in,
Yeah.
thank you.
No problem.
Just in there.
I'll send that to you, Kit.
Yeah, I've seen it on the presentation.
I think that is all for today.
Thank you.
Thank you.
Thank you so much for coming. It's been a real pleasure to hear from you, and we'll certainly hear back from the staff on the right reply. Thank you.
Thanks, Ra. Thanks, Julie and Christine.
Right. Matt and Joy Redshaw. Yes.
Previously circulated.
We've seen this before. Updated. Great. Excellent.
Thanks, Christine. Are you well? Good. Yeah. 333.
Thank you. Oh, she just.
Welcome. The floor is yours.
Before I start, perhaps we could have the photos later after my presentation. More appropriate, I feel.
Yes.
Sure.
That map. Good morning, ladies and gentlemen. It's still morning. This is on behalf of my wife Joy and myself. As an older couple wanting to enjoy the fruits of our labours, we are spending a bit more time at what we call our little bit of paradise. Beautiful place with grass clearings for the beefies, surrounded by native trees, many varieties, and a high altitude view down to the sea. Also a little hut built by our then 13-year-old son, some 37 years ago, to do possums from. We have, with my wife Joy's creative flair, turned the old hut and surrounding area into something we think is quite special to us. But it is right on the edge of the SNA, and our grandchildren love to go into the bush unimpeded. Having this project helps Joy keep motivated while she is coping with serious health issues. If fences get imposed around SNAs in the future, it is going to take this enjoyment away. Our family gets great satisfaction and pleasure from this, with 4 generations having been part of it. It is also essential for stock access to the grass areas below. We border the 5,000 acres of the Kaitaki National Park, part of the Egmont National Park. Isn't that enough bush without taking our rights away on this adjoining privately owned bush? Given that we have already outrightly gifted and also covenanted 4 hectares of prime bush back in 1989, and since have fenced to protect a further 7 hectares, which we would like to see in a QE2 covenant, we feel that our request to remove the 0.67 of a hectare from the SNA should be given the highest consideration. We don't consider that SNAs should be imposed at all, but it seems we have hit a brick wall in preventing them. All the work done to preserve this bush at our own costs, that being fencing, predator and weed control, was done out of our respect for what it means to us. To have others rule over us feels derogatory for what we have preserved. 7 hectares is 17 acres in the old terms. If that was in grass, it could be worth the value of an average house section. Yet we have never been offered any compensation for our privately owned bushland. We have never asked for any. Thank you.
Thank you very much. I'd like you to pan out a little bit just to see the other way, just to perhaps see just the context. Okay, there we go. Thank you. Anything else you'd like to comment about the location of the property before we go to your photos?
Well, you can see it's in the Kaitakis, which is the bushland around it.
Yes.
So it is in a big valley. Well, not a big valley, but our main farm is 78 hectares. So this bush that we've protected is almost a fifth of our farmland. And other bushland that we have protected as well as this. So.
And that's one of the ring plain streams obviously coming off the...
Yes, that
is
the Winyuriki River.
Yes.
It drains about 1/3 of the Kaitaki Ranges itself.
Wow.
So it's probably the main stream that runs from the Kaitaki Ranges.
Yes.
So it is quite hilly, our place, you know.
Yes.
Bush it could have been felled. Some people probably would have felled it. We felt it was better to us as bush, and fenced and protected.
Yes. Look, we're hearing a lot of, that's the feeling from so many people talking to us, that they truly value the history and the values of those bush areas. So it's a great effort you've done there. All right, there are some photos I think you'd like to take us through as well.
Photos are to show the enjoyment we and others get after a 1.5k hike.
Mrs. Redshaw, maybe just bring your microphone up just near your mouth, thank you.
These photos basically show the enjoyment we and others get after a 1.5k hike up very steep hills to see the expansive views. Comments from people include, wow, above the worry line, as you can see, you can see right down to the sea. Another is, my troubles seem to have disappeared. our 5-year-old grandson was excited to show his mum for the first time. Look at all this, and he flung his arms apart. You know, even for a 5-year-old, appreciated how special it is. He had recently camped there, and obviously his father had explained, you know, how precious it is to our family.
Mm.
So the next, that's the little humble old hut, but still waterproof and a source of water for overnighters and a trough for the cattle. That's well, I guess it explains itself.
Yes.
Natural, you know, with a vine growing around a tree, which I thought was rather special and made it into a, you know, a bit of art, I suppose, on the old hut.
Yes. So this was the hut your 13-year-old son built, was it? Is that right?
Yeah, it was just out of 2 car cases, basically.
Wow. Okay.
Yeah, I don't know if that's just the view of, you know, titivating around of something that's pretty, the old boots, and yeah, just we enjoy it there. It's just peaceful.
So the SNA line is directly behind the hut at the moment.
Okay.
It's 2 little grandsons just enjoying being there, and got their feet in a fire pit, which, you know, they just find pleasure without, they don't need toys. It's a big playground for them up there. Grandchildren, and they all love it. That's a friend. Many friends would go up there, and you know, they just enjoy it. And, you know, yeah, it just takes them into another level of relaxation, I suppose. Granddaughter, like we ride the horses up there, and it's a granddaughter, first ride up the steep hills and posing for the shot a while back. And that's another granddaughter, that's another view from the top of the hill. So we've got views of the mountain on a good day, and the puakais and the kaitakis from up on that ridge. It's 3 generations sitting having lunch over and had, you know, a fire and enjoying the smoke and all the basic things in life. Yeah, it's always a very enjoyable time with family up there and friends. Another view with 2 little grandsons around one of the tracks. You know, circle track loop around there. Yep. Thank you.
Thank you. It certainly brings to life for us the place you're talking about. So it's really awesome that you've given us that appreciation. Are there any other comments before we might have some questions?
Well, we want to pursue the QE2 side of it. We have gone down that track with help from Michelle and
Neil?
Just forget his name. Neil Phillips, sorry. Yeah, Neil Phillips, but he's departing, so the other 2 will take over if it eventuates, which we would like to see. So that's why we want the 0.7 hectares removed. So that is out of our recreational part too. What we've done for conservation, we feel that, like I said, should be given the highest consideration.
Okay, so that area is clearly defined. The staff know where the point.
Yes, that's where the
6,
grass
7.
is, and that's where the stock graze. So that's in between the national park and what we have fenced as part of the SNA.
Yes, there it is there. Okay. So So I'll hand over for questions from the panel. We'll go in the normal order. Thank you.
Oh, thank you.
Sorry, but the other SNA is just down a bit from that one.
Okay.
The bigger one. So there's two parcels of SNA.
Excuse me, sir, in Appendix 9.
You've got
That's
that's
map
for the
one.
mapping one. Great.
Fenced for 40 years.
Yes. Great. Okay, Commissioner McMahon.
Okay, thank you both. This is one of 3 properties where Rochelle has identified that there's a deferral of the mapping or scheduling decision on the planning maps until the end of the hearing. Next year, I think. Yes. And her paragraphs 351 to 354 outline your situation, which strikes me as a bit of a chicken and egg type scenario about the timing of entering into a covenant versus the potential removal of the 0.67 hectares. So I understand that dilemma. And so does Ms Macbeth. She said it's difficult as you're less inclined to enter into the QE2 covenant if your land's also subject to an SNA. I wondered if you could explain that dilemma more to the panel. What you do have an intention to enter into the covenant ultimately, don't you?
Absolutely.
Yes.
Yes, we've gone down that path. We have Neil Phillips in our submission has penned a letter to that effect. He signifies that it would be advantageous for us to go the QE2 way.
Yes. Miss Macbeth talks about the possibility of a memorandum of understanding or some agreement being entered into on the basis that when you do covenant, the SNA will be removed from your property. Have you investigated that any further?
Not a lot.
No.
That was my suggestion as a way
Yes.
through this process.
Yes. Okay.
So to us it seems the best option if that can be worked, rather than rely on what may happen with SNAs in the future. And the fact that we would like that 0.67 as our special little place.
Yes. I mean, I'm going to ask you a direct question. If it's as simple as including that 0.67 into a covenant, why can't you proceed to do that? That would give the panel confidence to remove the SNA over that part. Can you give us some confidence over the timing of that occurring?
Well, we thought initially that the 7 hectares, which excludes the 0.67, would be better to be the covenant. We feel that our 0.67 is our
Okay, so
our special place.
So you don't want to have that covenanted?
Well, if we don't really, if it can be worked otherwise, if what we're proposing is not good enough, then we feel we are not being fairly represented.
Okay. So you're saying that there's a greater good to be considered here, that the protection of the larger area is compensation for your use of the smaller 0.67 area. Is that what you're saying?
Well, pretty much, but as you can see, the 7 hectares is protected now.
Yes.
And if that goes into the QE2 covenant, that will be further protected as
Yes.
QE2. So all we're asking is excluding the 0.67.
I don't know if I...
Simplify our administration, our well-being and everything.
Yes.
Okay. No, I understand that.
Considering we've gifted to the park 4 hectares.
Yes. Okay. Thank you.
Just signalling to everyone that we've lost our Zoom link. So we think that Commissioner Littlejohn's...
No, I'm here.
Oh, you're here? That's great, because...
That's my screen I'm sharing. I've taken control from Auckland. We always do that.
Okay. So Julie just told me that she wondered whether you're still there, and she's rushed off to talk to the Zoom people. So
No.
So that's your screen with the Zoom on it.
Yes.
Wouldn't it like to see you back again? Is that possible?
All right. Oh, well, I was just going to ask some questions. That's why I put the plan up. I wanted the plan there, so that was rather than people rummaging through it.
We can't see the plan. We can just see a blue screen with a Zoom box in the middle.
Oh, all right.
You'll have to have the screen on your
Julie,
screen before you share it.
Kit's taking control, so that's why we're having a problem.
Aucklanders.
Bloody hell. Okay. Well, I mean, it was this plan that I was going to talk to. I thought that was easier. Here we go.
Appendix 9.
It's Appendix 9, Plan 1. It's this, and I just wanted to ask Mr. Redshaw about the 6,700 square metres.
Okay, so...
Are we all ready to go?
No, I'd like it to actually come up on the screen, so I wonder whether, Julie, you could put that...
Okay.
Are we...
Is that there now?
There now, yes.
Well, that's me. See, I've taken control again.
Yeah. Thank you. There's an OK box in the middle there, but we've got the plan up. So go ahead, Kit.
Okay. Well, look, of all of the properties that were discussed in the report, this was the one, I have to say, that interested me the most. And I guess I just want to understand, Mr. and Mrs. Redshaw, what you would suggest to us are the I guess the ecological or scenic differences between the area that you're happy to have as SNA and the area that you want removed. Are you able to identify what's the difference between those areas from a bush perspective?
Well, the bit that we want excluded has got grassy patches to it, which we graze with a few beefies. The two SNAs, apart from that, are totally bush. No grass, just totally bush.
Okay.
Our stock need to go through that bush to get to that grassy area below the green dotted line. You can see the boundary line with the neighbours.
Yep.
So there's a grassy area there, and the stock go from the top grassy area through that bush to that to graze.
Okay.
And there's the trough down there as well. And by it being by them not being confined, it actually stops erosion. I mean, we don't have a lot of stock up there, and we are conscious of the erosion. So, that grassy area, it looks like it's accessible from the bottom of the screen, but it's not. There's a gully there, and steep, they can't get up there to that grass.
So they come around this way, do they?
Yeah, we can't get along the other way.
Oh, okay.
We can't get from the bottom of this grassy area up to there.
Is that portion fairly flat in its topography, or does it drop away down into what seems to be a hollow in the middle of the SNA?
Well, yeah, there's a valley, a creek, a waterway, which starts below the shaded area, which we like excluded. It is quite a steep gully. Yes.
And are the tracks that the stock use to get through there, are they fairly well defined, and do they follow their way, or do they just wander?
They just wander mainly, but they do tend to go on a specific track, but not entirely, because it's open, and they just wander down to the grass and to the trough down the bottom, then back up again. So there is a trough up the top below the hut. There's also a track around the bottom of that brown area, the exclusion area, there's a flat top and bottom, so that's why that is where we would like it excluded.
Presumably,
right around this.
yeah,
Sorry.
presumably, if you were going to go through the QE2 route, that transit route for stock, I mean, if the QE2 covenant related to the full green dashed area, you'd have to stop because you'd have to fence the whole thing, and stock would therefore not be able to access that other side. Is that?
Well, that's why we do it like we're proposing to do it, exclude that area, and we can retain that as our private property again.
Yeah. Is there any reason why you apart from the fact that you don't want to, why you could not just have the QE2 covenant applying to the fenced portion and then leave the other bit of bush simply with the SNA overlay, which wouldn't require it to be fenced and would preserve your right to continue to run stock through it? Is that just seen as a bit clumsy from your perspective?
Well, Neil Phillips has actually looked at it and, thought that this was a good, outcome as well for QE2.
I have no doubt that it will be a good outcome from a QE2 perspective, whichever way it goes. It's just, I guess my concern is that the council and hence we are to some extent dictated by an obligation that if Indigenous vegetation is significant, that we need to identify it and protect it. And on the face of it, you're requesting us not to protect it. And that's just something I've got to grapple with, because there's no doubt whatsoever that what you've done for conservation is extraordinary, and so as have so many of the other submitters we've heard from. But whether that's a factor that determines whether Indigenous bush should be scheduled or not is something we're going to have to ponder. And it's a complex issue, but I can assure you we'll think about it long and hard. So thank you for clarifying that. Thank you.
Thank you very much, Commissioner Coffin.
Yeah, just a clarification for me. I think Mr. Littlejohn's questions have clarified most of the things I wasn't quite sure about on the map, but it was the white area, which is that the area that's proposed to be in a conservation covenant, or that's the area that currently is?
District Council Conservation Covenant. In fact, we actually own that land, but we have got no rights to do anything with it. It's in effect part of the national park.
Yes. Okay. So that's contiguous to the area that's been...
It was set up in the first place back in '89.
Okay. And that's contiguous with the area, the lot 1, which was the area that you had donated to the national park.
Yeah, we gifted that to the national park.
Yeah, thank you.
3 acres.
Okay.
Okay.
And I suppose that was going to answer my next question, was then the area in white and the area that's in lot 1, because one part of this is perhaps with the staff, because that's the area which is part of the national park, and the other area of the covenant that they're not included in SNAs.
That's why they're not included.
Yeah, okay. Thank you.
Thank you for your presentation. I have no further questions. We do appreciate your time and the very clear way you've set out the issue for us. We do understand, and we will certainly ponder, as Commissioner Littlejohn said. Thank you.
Thank you to the ladies who have helped us.
Thank you.
Thank you.
Is David Mackay here? Come forward, David. Sure. Mr Mackay, when you're ready.
Right, is that about right? Can you hear me?
Yes,
Great. Okay, yeah, thank you for this opportunity to put forward our thoughts on these SNAs. My wife and I, we are landowners in number 7 Hunter Place. Oh, there it is up there on the screen. So we've got a very small area of that SNA, but we've lived there since 2000, but we've owned the property since 1996. We've removed weed from that area, Tradescantia, old man's beard, ginger, tobacco weed. And whenever we get a small native that comes up in our garden, I usually try and repot it and put it on down in that area. And see, we have a lot of wow seed in our property, which overlooks our driveway. And when I sweep that, I throw that seed down here as well, because it grows quickly and it creates a canopy which excludes the weeds. And over that 20 years that we've been there, living there, the growth underneath and with the exclusion of the Tradescantia especially, growth has been brilliant. In addition to that, the removal of possums by the TRC, they've had what they call the Waiwakaio area, which has included this area. They've had a possum poisoning program, and the exclusion of possums allowed the undergrowth to come through quite extensively, especially koikoi. We had there is a large koikoi in that part of the section, and it's seeding prolifically at the moment. So one of my reasons for trying to ensure that we have a good bush cover on that area of our section is because it is quite steep. And I want to ensure that there is plenty of bush cover with differing root systems, differing depth of root systems, which will hold that land and stop erosion. I'm a civil engineer, structural and foundation engineer, and that has been my belief to stabilise banks. It's getting a good cover of native trees is good value. One of the issues that I see that SNA or some sort of protection for bush areas within the city is important, because we know that the average time that people live or hold an ownership of a property in New Zealand is about 7.5 years. The SNA proposal by the council is a long-term, and if you change ownership every 7 years, you're going to get, certainly in the urban area, obviously, you're going to get different aspects of people changing it, cleaning it out. They've got different ideas of what they want to plant, what they think is good. So to me, the philosophy of the council to get 10% of the land area in native bush cover, which will give it a sustainability not only for the bush cover itself, but also for the bird life, that that 10% is about a sustainable minimum that you need to sustain the bush, to regenerate on its own. The birds can live, and to me that is a very good goal that we should all be aspiring to. My other point was there's a draft policy statement out on biodiversity put out by the Ministry for the Environment. And that has similar sort of conditions or ideas, philosophies than what is I see the SNA proposals in the district plan being. I'm surprised though that biodiversity policy statement is not, or doesn't appear to be in the first part of the statement. There's a list of policy statements that sort of cover. I don't think the biodiversity policy statement is in that list. There's only
the reason is it's
a draft.
It's a draft.
And it was probably after the.
No, and it's still a draft.
Yes.
It's still proposed. It's not in effect.
No.
So that's why the plan wouldn't recognise it, and we can't really recognise it either. But I think we heard from the staff yesterday that the council is anticipating some of the outcomes from that policy and trying to be future ready for that type of thing. So that underpins their 10% aim for urban planting and native trees in and around the urban area. That's about right, isn't it?
That's correct.
Yes.
So when it comes out, would it automatically then be put in, or would some into the plan, or no?
The short answer is no, it wouldn't.
No.
I mean, it's the short answer is that it does not exist in this present form.
Sure.
So when plan makers, plan drafters are considering documents, they have to look at what the other higher order documents are giving direction. So regional policy statement has provisions. Section 6 of the Resource Management Act has some provisions in relation to Indigenous vegetation. The MPS on freshwater management has some relevance. So they are the current stock of or inventory of higher order documents that the plan needs to give effect to. If at the stage that the MPS on biodiversity comes out, the council may wish to undertake a first schedule process to change their plan.
Yes. Could a private citizen ask for that stage to be added into the plan as a change?
No, I'm not sure.
Yeah.
But the important point is that there seems to be sufficient guidance at the moment and direction, both nationally and regionally, for provisions to go into the district plan.
Yes.
So
I appreciate it.
Yeah.
All right. And I've talked, I'm just going now down through my list there. I've virtually talked about the 10%, which was in part 3. Part 4, I think it interests me that a lot of attitudes towards SNAs is that it has to have significant bush or significant types of trees or old trees or established natural bush. And because this one was farmed probably back in the 70s, that subdivision there was at the end of the 70s, early 80s. But to me, if there is, in an urban area, if there's little natural bush areas, then any Indigenous planting or regeneration, no matter the age or how small, will be significant. The significance is that there's little of it, and what we're trying to do is keep what we have got and enhance it and bring it up. So whether it's been cut over or whether it's existed since 1840 or beyond doesn't really come into it. It's a matter of we've got to keep what we've got there now.
I think that's one of the criteria the ecologists use. I think the rarity or the... Yes, so this is why we can see that this area has been identified for those very reasons.
I mean, yes, if one went through there, you'd probably say that it was, if you were comparing it to the mountain there, you would say it was probably insignificant type of bush. But there's not a lot of it in New Plymouth, and we need to keep that going.
Understand, thank you.
A lot of landowners seem to think that they, as of right, have exclusive rights to the land and they can do anything they like with it. But we have had well, as far as I'm aware, Town and Country Planning Act since 1953, which has had some...
1926, actually, yes.
Yeah. I believe that there would have been a previous one to this. So councils and governments have had some sort of input into how we use our land, and that's always been. Now, of course, it has, as we've become a denser population, we've had more and more intervention, if you like, by governments, and to me, that has been there because that's what the population of New Zealand want. Otherwise, we'd be throwing the governments out or councils out, and we would be moving on in a different direction. So the arguments that come up that people want that exclusive right to be able to do what they want on that land is being eroded all the time, and it needs to be. You see the way some people use their land. Yeah. I will just leave that there. In this particular SNA, this part of it, there are some trees there that may be exotic, but I think they would be very few and far between, certainly in the area around where we are. And I used to weed certainly outside of the boundary further down, because it's quite steep and I weed virtually right down to if you go straight down that parallel to the side boundaries, virtually to where that house is excluded from the SNA, to do the weeding. There would be very little exotic tree in that area. The odd cherry, that would be it, other than the weed species, of course, there. But most of those have gone now. I believe that with the cover that's come up, weed species are starting to die off. Less of a problem. One of the problems will be that some of the planting that I know I've planted a beech tree there, which is quite out of keeping really with natives. And up until a few years ago, I was probably less, the eco-sourcing of native planting was less of an issue to me. I'm a bit more concerned about perhaps that eco-sourcing of plants should be important part of that. I don't know whether you need to make rules around it, but certainly one of the problems in an urban area is that there's so much other bush planting in people's gardens that you're going to get natural hybridization, whether you have rules about eco-sourcing of any planting, bit dubious about. we certainly know, I'm surprised that there weren't more submissions in support or fully in support of SNAs. A lot of the submissions seem to me to be supportive in part, but not on their land. They wanted the control over their land. To me, general public do appreciate bush in the city. And certainly the two gardens on either side of us who have been in the Fringe Festival, garden festivals, they both advertise their gardens as having, one of them says a short bush walk and the other one says a bush view, and actually calls their garden bush view. Funnily enough, the bush that they view is the bush that we've enhanced. You can see that patch on the northern side of our boundary, down the furthest from the street, which is cleared of, doesn't include the SNA. The SNA does not cover that, and that's where they dump their garden rubbish. I am concerned some of the rules, or some of the hearing concerns that people have about the rules encroaching on their rights to do small maintenance, and I don't think that is the case. But that is the concern that people have, and that's their reason for objecting to SNAs. The rules will need to be reasonably flexible and not incur too many costs to the landowner. If I've heard of issues where people have been taking, say, cherries or something out of a bush area, neighbours have complained and they've had to end up getting an ecologist to come in and do a report on that what they were doing was acceptable, and it's cost them money. To me, the reason we've got these, the council want these SNA areas, is because the public enjoy them. And the public should be prepared to perhaps pay for those exceptional costs. In other words, the council should cover those costs as part of their good for, like they maintain our sewerage systems, they should maintain our bush systems as well, because it's part of the overall feeling for the city, keeping the city right. I know that you've said that the resource consents will be, to get stuff done in an SNA will not cost anything. I think that's good to know, and perhaps that should be explained to a lot of these landowners that are concerned about losing that role. And obviously, I think some of the rules that appears to have been put into the plan have come from the rural rules that were out there in the rural areas, and they don't really apply, certainly with the ones with fencing and that sort of thing. It's obviously not necessary to fence something like what we've got there. And I don't know that that is a request of this district plan. But to me, there's a different set of rules needed for the rural area and for the urban area. I've also mentioned that Maori land, which has SNAs, again, probably have to have a different set of rules as well, in my mind. So I've mainly confined my comments to this SNA, but I think I'm supportive of the SNAs over the whole city. But this is the one I know about, and I know about the detail. So really, that's all I have to say.
Thank you very much. We'll just see if there's any questions.
Certainly.
None from me, sir. That's very clear, Mr. McKay.
Commissioner Littlejohn?
No, thank you. I very much enjoyed that. Thank you for your presentation.
Yeah, Mr. McKay, the other part of your original submissions was regards geopreservation sites, I think specifically fossils, is that right?
Oh, that's yes.
And I don't think we're hearing you again, I don't think so. I think this is I didn't see you in the schedule for any of those.
No, I haven't. I wasn't going to submit.
Had you seen the staff recommendation regards to the fossil sites? My understanding of it was one of the key issues that they have is making sure that any, what they're calling geopreservation sites, is a capture-all of a number of different types of geological features, including fossils, need to be accurately located in terms of mapping and in an engagement process with landowners and making sure that everybody who's affected by that are clearly involved in that before they are put into the plan.
It's an interesting one, because I don't know of any sites in Taranaki, and I suspect from my geological knowledge, there's unlikely to be, but I know the problem they had in Otago, which you guys will probably know anyway.
Okay.
And one of their problems was that it hadn't been identified, and they had no mechanism in which to protect it. And I thought that the district plan was somewhere where, if something was found, they'd be able to.
Yeah, I don't think that's actually the contention. It's more where there are sites that they need to be identified clearly and a process for making sure that everybody who's affected, particularly the landowners, have an opportunity to have input into that. So I just thought I'd just raise it because I don't think...
I know in Otago they were wanting to mine it.
Yeah. And I think this might be the only submission we've received on fossil. Yeah, that's right.
Probably.
So you're a lone voice, I'm afraid.
It's just that at the time I hadn't belonged to the Geological Society, and they had the Otago people up here giving a talk, and it was just to me, it was just a wonderful experience to see those old fossils, the photographs of them, because they were perfectly preserved. And they had no way of protecting them. They were having real problems. I just thought, well, the plan's going ahead, we might just bring that up.
Yep, no, appreciate that. Thank you.
Mr. McKay, just out of interest, your professional engineering career, was that in Taranaki?
No, I was, we lived in Auckland for 20 years, from 75 to 93, and lived in the Waitakere, which is why we enjoy bush.
Of course. And you've moved to Taranaki, it's a beautiful place to retire to.
Well,
obviously.
no, we moved in 93, so we didn't retire here, we just had a change of...
You had a change of direction. That's great. And look, I'd like to just thank you. The attention to detail and evidence from professional people that have so long an experience is very, very helpful. So as a citizen, being involved with your thoughtful submission is just fantastic. I'd like to thank you very much for your thinking, your presentation. It does provide quite a balance to some of the other evidence or submissions we're hearing, and I think yes, it's very, very thoughtful, as I say. So thank you very much.
That's why I put it in, because I knew there would be submissions from the other direction, and I didn't think there'd be many from support.
Thank you for your assistance.
Right. Thank you.
Ms. Durand, are you here? Yes. Apologies for the pronunciation. Just tell us how your surname's pronounced.
Carente.
Carente, okay.
I like Spanish.
Yes. Is that are you from the Philippines or?
Yes.
Okay. Awesome. Thank you. So you have a written statement?
Yes.
Yes, thank you.
Good morning, commissioners, officers, guests, and submitters who are here today. before I start, I would like to acknowledge the efforts of our commissioners and officers in our hearings. My full name is Sinaida Herente. I'm a senior planner of the consultancy firm LandPro Limited, and I'm based in its New Plymouth office. My evidence addresses the parts of LandPro Limited's original submission on the ecosystems and indigenous biodiversity, water bodies, and public access of the PDP as they relate to the recommended amendments in the officer's section 42A reports. So under ecosystems and indigenous biodiversity, LandPro Limited's original submission point 475.8 sought to include minor vegetation, grants, track work, earthworks, and structures in SNAs that is for public access as permitted activities. In my evidence, I provided clarity on what type of track being referred to in LandPro's submission, and this refers to tracks for cycling and walking. Public access basically comprises cycle and walkway tracks. The provision for public access along the coast and water bodies is one of the objectives in public access chapter. So not including the installation of cycle and walkway tracks in Eco R1 as a permitted activity or not having a clear consent pathway, I consider that it contradicts the objectives and policies of public access chapter. This does not align also with the region's, districts, and Waka Kotahi's walking and cycling initiatives. Biopolicy 7 of Regional Policy Statement, or RPS, for Taranaki also recognizes the need to consider social and economic benefits of appropriate use and development of resources for balancing biodiversity values and community benefits as to be taken into account. I recognize the importance of New Plymouth's significant natural areas in managing and maintaining our district's indigenous biodiversity. So I recommend that the indigenous vegetation disturbance for the purpose of establishing cycle and walkway tracks be a restricted discretionary activity, and I propose matters over which discretion is restricted. Some of the recommended matters for Eco R6, the officers' recommended amendments, have been adopted here. I consider that this approach is more appropriate as this enables reasonable use of land in significant natural areas without compromising its indigenous biodiversity that is consistent with the objectives and policies of the PDP and the RPS for Taranaki. So under water bodies and activities on the surface of water, for earthworks, LandPro's Limited Regional Submission 475.3 sought to include track, road, path, or walkway over the bridge, culvert, ford at installation, and maintenance or upgrading of track, road, path, or walkway over the bridge, culvert, ford as permitted activities. LandPro Limited also sought to include volumetric limit. I concur with the recommendation of the Council Planner to include existing tracks as a permitted activity under WBR4. However, LandPro Limited refers to both existing and new tracks in its submission. It is noted that the officer's report has not provided an explanation for only considering existing tracks. Again, for clarity of LandPro's submission, the tracks being referred to in the original submission pertain to cycle and walkway tracks. I consider that the earthworks associated with the installation of new tracks would not have more adverse effect on a water body than erecting bridges, culverts, fords, jetties, or boat ramps, as tracks are usually located with adequate setback from the bank for safety and erosion avoidance. So I recommend a minor change to the officer's recommendation to the rule WBR4, where cycle and walkway tracks be included as a permitted activity in addition to existing tracks. I consider that this is more appropriate as the potential adverse effects of earthworks associated with the installation and maintenance of cycle and walkway tracks already has a consenting pathway in the Regional Water Plan of Taranaki. I accept the officer's findings on the submission related to volumetric limit. Under setback distances, Landpro Limited's original submission point for 75.20 sought to allow minor vegetation clearance, track work, earthworks, and structures as a permitted activity within 5 meters of water body and 10 meters of a significant water body that is for public access. I consider that the other points of this submission have been addressed in previous topics, except for structures. The opinion was provided by the officer on the submission point on structures. I note that in the officer's report, it was interpreted that Landpro Limited submission supports the building setbacks as notified, which is inaccurate. However, I recognize that the submission point will be inconsistent with WB. Therefore, I concur with the recommendation of the officer's report on setbacks for buildings of 5 meters from a natural water body and 10 meters from a significant water body, and support the activity status for structures or buildings not meeting these minimum setbacks as a restricted discretionary activity. I note that referring back to the matter set out in WBP1, WBP2, WBP3, and WBP6, for matters over which discretion is restricted for structures or buildings, is not straightforward and easy to follow. Some matters in one policy are also considered repetition in other policies. I also consider that including the matters set out in WBP1 for the rules for scheduled water bodies and assessment for restricted discretionary activity is redundant, as these matters have already been applied in identifying the scheduled water bodies. I also note that the second matter over which discretion is restricted, that is, whether the activity would create new or exacerbate existing natural hazards, including flooding or stream bank erosion, is one of the matters set out in WBP3. Therefore, this is also redundant, as the matter set out in WBP3 is included in the first matter. The relief sought in this is the deletion of the matters related to WBP1 and the second listed matter. In my opinion, it would be more efficient for the plan users if the matters from WBP2, WBP3, and WBP6 be listed or itemized as matters over which discretion is restricted. Under public access, Landpro Limited's original submission point for 75.28 sought to allow minor vegetation clearance, track work, earthworks, and structures as a permitted activity in 5 meters of water body and 10 meters of a significant water body that is for public access, provided not inconsistent with overall conservation objectives of SNA and water body policies. The officer has pointed out that the minor earthworks in the submission was not defined. The minor earthworks in the submission refers to earthworks associated with the installation and maintenance of trucks and fences. I concur with the findings of the officer that the addition of trucks as a permitted activity in water bodies chapter means that all the earthworks associated with trucks and bridges would be permitted activities in both public access water bodies chapter. I also consider that the minor earthworks in the submission point has been addressed. However, the proposed change has only considered existing tracks, and therefore the officer's report has not completely addressed the submission point for 75.28. As I pointed out before, public access basically consists of cycle and walkway tracks. Therefore, it is important that installation, maintenance, and enhancement of such tracks is a permitted activity. As I have recommended earlier, cycle and walkway tracks should be submitted in the list of permitted activities under the water bodies chapter as discussed in paragraph 19 of my planning evidence. That concludes my summary of evidence.
Thank you, Zine. I'm sure we'll have some questions. Starting with Commissioner McMahon.
Yep. Yes, good afternoon. I'm going to keep these fairly general. The flavour I'm picking up is that you're seeking a more permissive regime, a more enabling regime for cycling and walking tracks.
Yeah, for new ones.
For new ones, yes. And I guess the starting point for that is Section 6 of the Act, Section 6C, which talks about protecting Indigenous vegetation from inappropriate subdivision use and development. And the officer has rejected submissions which seek to alter the objectives in the proposed plan, asking for those words, inappropriate use and development, to be added into the objective. Instead, she's said the best method of doing that is to have the policy do the heavy lifting on that work and define what is inappropriate subdivision and development, or alternatively, what is appropriate subdivision and development. That's what I understand her general thesis to be in that respect, and I understand that. And so what we see is the plan making provision, or cutting some slack, if you like, for activities such as regionally significant infrastructure, utilities, farm tracks, fencing, which, although the officer may not have used these exact words, are deemed to be appropriate or not inappropriate activities in terms of protecting Indigenous vegetation. So it's a long essay in asking you what's the basis, what's the higher order direction for providing the same enabling relief for cycle and cycle that exist for, say, significant or regionally significant infrastructure. Is there any parallel between the two that you can draw the panel's attention to?
Yeah, it's just that we have this cycling and walking initiatives that been promoted by Wakakotai and the region and district. So it would not be aligned with that if we going to establish new tracks, and that would be a non-complying activity. Then that's kind of like doesn't enable the activities to be done. I don't actually propose that it would be a permitted activity.
I understand that. I mean, for example, in relation to vegetation removal for, just lost my screen, for enabling cycling and walkways, you're proposing a restricted discretionary activity.
So discretionary, subject to the matters.
Yep.
Yeah, important.
So what I'm trying to ascertain is what support is there for that proposition in, say, the regional policy statement or in other documents?
Yeah, so I've mentioned in my speaker notes that we have this Biopolicy 7 in RPS of
yes, I wrote that down.
Taranaki, yeah.
And they talked about social and community benefits.
Yeah, which kind of like enables as long as it benefits.
Okay. Can you point to anything more specific than that? Well, it's a fairly generic policy, isn't it?
Yeah, it is. But if we make a proposed activity that's aligned with this as a non-complying activity, it's kind of like contradicts with it.
Okay.
Yeah, I don't say that it will be permitted activity. It will still need resource consent, but still addressing those matters that are important under.
Okay. And as a restricted discretionary activity, the activity could still be declined?
Yes, if it doesn't meet the matters that's under. Yeah.
Okay. Before my screen died, I noticed that some of the matters of discretion were quite broad. I'm sure Commissioner Littlejohn will have a comment on those, particularly the relation to the one dealing with avoid, remedy and mitigate. So I'll leave that for him. But that's all the questions I had, sir.
Thank you. Commissioner Littlejohn.
Thank you for that. I guess first one, when you use the concept of a walkway and a cycleway, do you have some? I mean, just describe to me what you're thinking here, because, and the only reason I say it is I come at it from, I guess, the big city view of a cycleway and a walkway, which is a 3 metre wide shared path with, you know, access for cycles on hot mix going both ways, with retaining walls for ramps and all of that sort of stuff. They're quite an edifice, really. I don't suspect that's what you're talking about when you're talking in the Taranaki context. So I just want to get a sense of what you're thinking that these new cycle and walkway tracks might involve.
Yeah, actually, this submission point was not originally written by me. So it's because it's a concerted efforts of the planners in Landpro Limited. So when I discuss it with the original submitter, I think the reason behind it, it's because of a resource consent that they recently lodged, or maybe a year ago, which is related to the tracks in one of the parks, the reserve areas that we have. And then because of these rules that come into legal effect, then the tracks becomes a non-compliant activity, which until now they don't have a consent of doing that just because of these rules. So that's actually the reason behind the submitter.
Yeah, I wasn't questioning you about the reason behind the submission. I was trying to get a sense of what was the scale of these tracks for walking and cycling that you're suggesting that this rule would allow. And I was using the I guess the extreme example of what they can look like in a sort of a heavily urban setting, and I just want to get a sense of what you might be thinking about in the context of New Plymouth District.
I'm thinking of the tracks that we do have now, like along the Waterbodies that we actually are already existing now. Yeah, it's kind of like, what if in the future we would like to extend those connectivities with our existing public access corridors. So it means that if like, for example, Taranaki Regional Council would like to extend those tracks, then they need to go into consenting pathway, in which that would be a non-compliant activity if there would be under SNA overlays.
So you're not trying to limit it to cycle or walkway tracks that wouldn't require extensive land modification or sealing or concreting. It would include the full range of a 2 metre wide concrete pathway for cycles to come and go on.
No.
Okay.
Just to clarify that, are you saying that it wouldn't, your vision is not including the heavily constructed concrete cut pathway, something?
When as I understand, when this was originally written, it's more of the tracks that actually within our open space or
which
areas,
are not necessarily concrete or sealed.
Not necessarily. Yeah.
Okay, so that's the vision. Do you think this is from around the more low key, fitting in with the landscape rather than being highly constructed? So I think hopefully that clarifies things, Kit.
Yeah, thank you. I think that clarifies it for me. As Commissioner McMahon pointed out, the suggestion for your matters of discretion is probably inadequate for it to be restricted discretionary. But I mean, I think you're right to find a halfway house here, because under the existing rule and policy framework, which I know Ms. Macbeth has called precautionary, I tend to think what she's really meaning is that it's very much avoidance based, which means that you elevate up the consideration of a proposal based on the nature of the resource you're affecting. there is no proposition for new tracks. And in the absence of amending policy Eco P3 or making provision for a separate restricted discretionary activity, you really can't find a consenting route there. Or if you could, for example, you'd have to do it by then relying on P4, which would require you somewhat perversely to provide compensation or offsetting in an ecological sense to offset a track which has various other community and public benefits. So that's something I'll tie myself up with for a while, providing a different set of benefits to offset another set of benefits. But look, I can see the point you're making, and it's something I'll clearly turn my mind to with the commissioners, because I do accept fundamentally that the ability to create new tracks, even though it may have physical effects on the environment during the formation phase, have a range of other benefits as well, and it's a question of how you strike the balance between those propositions. So that's all very clear. Thank you, Mr. Chair.
Thank you. Commissioner Coffin? Yes, I do have a couple of comments, and this is something just following on from what Commissioner Littlejohn was saying, and I would like to hear a bit more about this when the ecologists perhaps come back to us. I'm aware of a theory around ecology that one of the most effective ways of protecting special areas is to allow people into them, to experience them, rather than locking the gate and hoping for the best. Certainly, I've read papers by Professor Craig from Auckland University. He's a strong advocate for letting people in to see and to experience these special places, which of course needs some access to do that. So certainly, I'm really interested in your submission and your evidence. I think it does raise quite an important issue, which has both a planning element, but this wider social, there's two things at play. I understand that in this sort of general theory that people who get into and enjoy the open spaces in the bush are more inclined to perhaps plant and donate and be involved in looking after places. But it's also got this social, we heard from the rituals, for example, about the pleasure that people have with their families and children about actually being in amongst. There's those quite tangible feel-good factors around this as well, but you can't get in amongst it if it's all fenced off and you can't, particularly in urban areas. So look, I do think you've raised some important issues. So if we could hear back on that, just in the right reply, just around that ecological theory. But your paragraph 27, this is where you're talking about the matters of discretion actually being the policies themselves. And I think you're suggesting in the way you've written up your track changes that perhaps it might be better to list those out as matters rather than just referring to the policies. Is that your suggestion? I'm looking at page.
Yes, that would be my suggestion as an improvement to the PDP.
Yes.
But not really, I'm not really recommending it, but it's just a suggestion for them to consider, to itemize the matters.
Yes.
Yeah.
It's something I don't know whether you've seen our minute 14, which raises these questions about the way the matters of discretion and matters of control are framed, and we've asked for the staff to think about these matters. So again, you're thinking perhaps along the same lines, it might be clearer to the plan user.
Yeah, as a
Yes.
because I've been using this plan every day, so
Yes.
it's something that we actually notice.
Yes. Okay. And look, as a planning company, and certainly you taking the time out of your day to come and present this fantastic work, really do appreciate your time and your advice as an experienced practitioner. So thank you very much.
Sir.
Commissioner McMahon has another question.
Not a question for the submitter, but just something for Ms Macbeth. The way I've understood, I mean, you haven't recommended any changes in response to the submitter, any substantive changes, have you?
No.
No. Okay, that's not a criticism, that's just an observation to make sure I'm right.
Policy P3 and at the start of the hearing I changed the and to or.
Yes.
So at that policy level,
Yes.
tracks for non-conservation purposes are envisaged at the policy level.
Yes.
But still needing consent and non-complying activity in this version.
Yes, and it just strikes, that's good, and I just want to make sure I was understanding your recommendation there. Your general approach has been to let the policy do the work and in the main not change the rules and let the policy open the gate for a consenting pathway. The exception being in the, where is it? In the coastal environment area under Eco R2, you have added in clause D the operation, maintenance, repair or upgrading of existing network utilities. And I'm just wondering whether, or two things, whether there's a need to differentiate both at a policy level and a rule level, IV that's in an SNA versus IV that's in the coastal environment. So at the moment, policy P3 deals with both, doesn't it?
Yes.
Yes. That's intentional?
Yes.
Yes. Yet we have some rules that differentiate between activities that are solely within SNAs or solely within the coastal environment.
Just R1 and R2 are separated out. Yeah,
Yes.
based on that identification.
Yeah, but they take their derivation from policy P3 though, don't they?
Yes, they would both cascade from
Okay. You don't see the need to differentiate the policy between the two resource areas?
Have considered that in light of the submissions related to policy 11 of the NZCPS.
Yes.
Yeah, have considered that and
said no.
There's merit in doing that. I guess it's just the interest of having a chapter that's more succinct where it can be.
Yes. Okay, so if the real emphasis is on P3 to provide the consenting framework, and I'm not talking solely about tracks here, I'm talking about other, what might be deemed to be other appropriate activities, or not inappropriate activities. Do you think, I mean, if I'm looking at clause 1B under P3, where there's some policy slack created for regionally significant infrastructure where there's no practical alternative. So coming to the resource consent for a non-complying activity, very clear direction as to what the consent authority and consent decision maker needs to investigate. If you go up to A on that same clause, which is the operation, maintenance and repair of existing tracks and structures, that seems to be much narrower than the regionally significant infrastructure, because the regionally significant infrastructure seems to be dealing with both existing and new. And I'm just wondering whether it's a long way of asking you the question, sorry, I'm just wondering whether there's some scope to broaden out clause A to provide some policy relief so that it doesn't relate to just upgrading of existing tracks and structures, but provide some policy consenting pathway, at least for new tracks in the same way that you do in B for regionally significant infrastructure. Is that something, well, firstly, through that garbled explanation, can you understand what I'm asking? And B,
would it be some kind of merging between 1A and 3? And clarification around what a track?
Yeah.
A scale.
What was the intention of 3 with those cross-outs?
It was for tracks for for recreation purposes.
Okay, yeah. Again, I was reading it in the narrow sense, yes.
Yeah.
Okay. But yes, so maybe,
And-
I guess, given the reliance on policy, on the policy framework to create the consenting pathway for acceptable or appropriate activities, I just think that it would be useful to have some more direction there, some more enabling. I accept what you're saying. Well, I understand what you're saying about not providing that relief in terms of the activities themselves and the rules. Let the policy do the work, and it's up to the the applicant to prove the need.
Yeah.
And I just wonder if that's the case, some more guidance in P3 might be useful. And I know we're not just dealing with this particular submission, it's submissions that I guess Federated Farmers and the telcos will raise too, that, and it just struck me in day 2 that this is something that could be investigated.
And building platforms as well.
Exactly.
Yeah, and who else? Who knows what else?
That's right.
Yeah. Yeah.
Thank you.
Thank you, Commissioner McMahon. Thank you very much. Right, we have Federated Farmers and Mr. Hooper. There's a feeling that maybe we've had a long morning and whether we could talk to you after lunch, or do you have a preference to go now?
To be honest, depending on the questioning, I don't think it will be long, which for reasons I'll explain.
Okay.
But, yeah, so I think it would be preference to go now. And I'm sorry, Mr. Chair, because I haven't asked your leave for that. It was a bit late to make notice, but Mark is attending via Zoom.
Oh, of course.
So,
Yes.
yeah, I trust that that's okay. So, and,
Yes. Well, welcome, Mark. Well, welcome back, Mark. Good to see you there. Okay, we will take we will take a 5-minute break just for conveniences, and we'll just sit. Anyone else is welcome to use the conveniences too. Right. Yes, thank you, Hilary. Welcome back.
Hi.
And Mark.
yes, so good afternoon. You with us, Mark? Loud, isn't it? Cool.
Yeah, I can hear you. Thank you.
Cool. Okay, well, I've got some prepared evidence that we'll work through, and then Mark's available for any questioning and to provide some more practical examples. But I will also just say, straight up, because I think our evidence may be slightly unexpected in that we're taking a relatively broad and supportive position at this time. So I don't want that, well, I want to be really clear that you've heard evidence over the last couple of days, some really good examples, some case examples where there are, some implementation issues that do need working through. So, I hope this doesn't sound counterproductive, but just don't want our relatively supportive submission to kind of cut across that, because we appreciate that there are some implementation issues to still work through. So, saying that, the other thing is, we were going to bring a fair few members with us. We know you've heard from some farmers doing individual submissions as well, but we did want to bring people along to reiterate why that light touch or the regulatory light touch goes hand in hand with good environmental outcomes. We wanted to share some of the great environmental work that's taking place on farm, including those that have worked hard to achieve the Towards Predator-Free Taranaki goals, those that have been utilising the Taranaki Regional Council environmental farm plans, and those who could share some of the work that the Taranaki Catchment Committee has been facilitating. We did decide against that though. Over the past few months, it has been sort of the busiest on farm. It's the busiest on farm for the calendar, and over the past few years, these have been the busiest and continue to be the most stressful period of central government policy making, signalling transitional change in farming practices since the 1980s. Farmers over the life of the operative plan were faced with significant fluctuations in income and escalating costs. If ever there was time and opportunity to increase production on farm to offset those costs and to shore up some certainty by converting bush to pasture, it was over this time. That didn't happen, and action speaks louder than words. The farming community and farming leaders have already put in the hard yards with this planning process, most specifically during the pre-notification consultation period, but also during the submission process and opening up their properties for ground truthing. The hard work has resulted in a notified plan and Section 42A report recommendations that we think New Plymouth District Council can be proud of, and more importantly, that is defendable with regards to these hearing topics. So instead, we chose not to worry or stress out our members unnecessarily, to ask them to come and defend a council plan that is landed, to defend where a council plan is landed, and to feel that inappropriate weight of responsibility. The actions, the processes, the hard yards are all outlined in the various council reports and recommendations. So you have me to work through the process a bit systematically and dryly, instead of hearing and listening to inspiring examples from those with actual skin in the game and dirt under their nails. You can blame MPDC for landing the notified plan in a pretty balanced way for that. The matters assigned to this hearing relate to public resources, biodiversity, water, access and landscapes. Our interest in these matters relate to how MPDC is meeting these functions and responsibilities for those public resources or assets when they are found on private land. We are interested not only from a land use perspective, but also as representatives of ratepayers who are acutely aware that goals and aspirations, no matter how worthy or well-intentioned, always come at a cost. These include financial, time and opportunity costs. Farmers are uniquely aware of these costs, as their properties are not only their home, the place where they raise their families, where they draw strength, pride and identity, but also their place of work, a productive place, a business, with many, many moving parts, most of which are outside their control, that needs to generate income enough to support their families, to support their staff, support their livelihood, support their livestock, support their environment, support their bank, and then with whatever is left to try and achieve the aspiration and goals they may have inherited from generations before them, or that they may have for generations to come. Rightly or wrongly, farms are valued at their productive potential. Debt levels reflect that. We remind the panel that you can't be green if you're in the red. Now this may be an oversimplified and overused adage, but it doesn't diminish the cold hard point it is making. Public resources and how they are managed on private land is always going to generate interest. It is easy to seek stronger land use controls when the impact of that increased regulation either doesn't come with a direct cost or is under the genuine but misguided belief that stronger controls equals stronger protection. The only thing stronger controls protect is the ability to prosecute, to make someone pay for intentional or unintentional harm or damage done. If an area of bush is sprayed out or a water body bulldozed, the ecological and cultural values are gone. Words on the page of a district plan cannot bring those values back. The only real and material protection for the range of values that have been discussed with these hearing topics come from people, knowledge and relationships, essentially from action, not restriction. Now, in accordance with your minute 3, which was about the final procedures for hearings of submissions, we are just focusing on the areas of agreement and disagreement with the 42A reports as they relate to this topic. And whilst already alluded to, it is worth being clear and upfront that we could agree considerably more than we disagree, and as such this statement is relatively brief. And it will explain why this hearing topic is perhaps unexpectedly uncontentious for us at this time. So with the exception of a couple of points, we are relatively comfortable with the 42A report writer's recommendations on the submissions and the further submission points we have made on the sections of the plan assigned to this topic. I have read the 42A reports and largely agree with the reasoning provided to support the recommendations made. It is worth making mention that some of our members have made their own submissions and hold differing views with regards to regulatory methods being used to meet Council's RMA Part 2 responsibilities. These positions are often principally based, and we fully support individuals' rights to their own opinion and the right to engage and make their voices heard in this space. It is also worth being clear that from our perspective, the low number of farmer submissions can be best described as reluctant acceptance, not silent approval or support as such, but acceptance that has come from the significant amount of work the Council and stakeholder working groups did post the 2015 Royal Forest and Bird case, and through this district plan review, to educate and inform landowners. The notified plan represents a significant shift from the operative plan. Within that context, and for the SNAs in particular, the degree of acceptance has been achieved through a good identification and landowner engagement process, and the broader stakeholder engagement which was undertaken during the drafting stages. It is the clear commitment to draft workable rules that has been influenced by it has been clear that the commitment to draft workable rules has been influenced by a good landowner-council relationship and the knowledge exchange which took place during SNA ground truthing site visits. So we take the opportunity to acknowledge the work that NPDC has put in to notify a plan that they can be proud of and, more importantly, defend. It is our members' expectations that Council will remain confident that it strikes the right balance between resource use and resource protection. We know that balance is not easy to land. I do belabour the point a bit because it would be doing our members a disservice to leave the hearing panel thinking that the lack of submission numbers and opposition from farmers is because they believe regulation is the best way to achieve positive environmental outcomes, or feel that they have got off lightly. Over different times, I have heard different planners comment that if no one is happy with the provisions of a plan, then they must have landed it about right. I know it is a relatively flippant test, but there is some strange logic to it. And looking quickly through the hearing evidence that has been circulated to date, the 42A report writers may be able to draw some satisfaction from the fact that the no one is happy test has been met. So before turning to the specifics of the chapter, I did want to make a general comment about the influence of exposure drafts. It is always interesting when there are draft higher order instruments in play. It is difficult for submitters to resist the temptation not to cherry pick the parts of the draft that work to further their interests and ignore the parts that don't. In my view, it is not for us at this stage of the district plan review to preempt or second guess how final versions will land, or to rush the implementation process of those that have been recently gazetted. The final versions will always include transitional provisions to facilitate appropriate implementation processes. And I do just want to add, in response to the questioning about the status of the NPSIB, it is our understanding from a number of sources actually that a further iteration is going to be released for consultation before gazetting. Perhaps not full public consultation, but stakeholders will be getting an opportunity for further input on what must be a fairly final draft, exposure draft. In response to the issues raised in the far north, the Associate Minister Shaw made it very clear that further work was going to be undertaken and circulated. And the MFE website does confirm that, although the process is clearly running behind schedule. Right, so my first point was just around public access, and I do appreciate the comments that were made this morning, although it's probably worth just racing through the points that we had. So we made a number of submissions and further submission points on that chapter, and our remaining concern really does relate to the fact that the spatial layer on the planning maps doesn't differentiate between actual public access and aspirational access. The dotted green line is used for both. In our view, that is inconsistent with the policy approach outlined in PAP1, which specifically states, identify and map public access corridors that provide access to the coast and water bodies. Provide being the operative word in our view. Now, the policy is fine in itself. It's the planning maps that are the problem, because plan users may inadvertently assume public access is available, when it actually isn't. There is also no problem with identifying a strategic plan of future aspirations for a connected network. It just should have a different spatial layer on the planning maps and a specific planning approach, that's all. So we understand that our concerns have been understood and accepted, but the solution was to add an explanatory text into the overview section. We don't think that will have much material effect, to be honest, because plan users are likely to just go to the GIS section of the plan.
Yes. So what's the solution then?
I'll look forward to what we're hearing was discussed this morning. Yeah, I don't have a solution necessarily, other than I would have thought some different delineation, even in coding, or Other councils have used strategic plans that sit outside the RMA plan for the ideal, for the aspirational access, I guess, and that has some merit as well. Whether there's scope for that, I'm not sure,
But if planning maps are to be used, and given the GIS approach and the
Yeah.
E-plan approach, it needs to be clear from the planning maps.
Yeah, and we just didn't think a note was necessarily going to achieve that, to be honest. But fully accept that the intention's understood, or that the issue's understood. So moving on to water bodies and activities of the surface of water. The key issue for us in this chapter relates to esplanade reserves and strips and the requirement under policy WBP4 for them to be taken in a high number of circumstances. We have real concerns that the policy direction will create ad hoc and random pockets of public access and create operational frustrations for the council and increase weed and pest excursions on neighbouring private land. That said, we appreciate waivers can be sought via the consent process and consider policy WBP5 provides useful circumstances which flag that discretion within the policy settings. In response to requests to extend the planning approach to all water bodies and tributaries, we agree with the reasoning outlined in paragraphs 144 and 145 of the 42A report. And we also want to be clear that we don't consider it as appropriate to add new water bodies to Schedule 9 without giving affected landowners the opportunity to be involved. Nothing frustrates landowners more than not being recognised as having rights and responsibilities greater than the general public when planning responses apply directly to their properties. This was supported at paragraph 307, and at paragraph 306, Ms Young discusses the work that Taranaki Regional Council is currently undertaking to implement the MPSFM 2020, which is likely to influence MPDC's planning response in due course. On to the natural features and landscapes. There isn't anything particular to highlight with regards to that chapter. We are relatively comfortable with the approach that's been taken. So finally, ecosystems and Indigenous biodiversity. This information has already been highlighted, but we think it's worth to reiterate for context purposes. There is approximately 20,000 hectares that have been protected as SNAs and 58,000 hectares protected through various other mechanisms outside the district plan. That is a combined area of approximately 27% of the district.
27 or 37?
Sorry, yeah, 37. There you go. It's quick 10, get it already. Sorry. So, a number of submitters are calling for increased regulation outside SNAs, citing ongoing biodiversity loss. However, the data used to support those positions are based on historical practices which were sanctioned by governments of the day. The panel seems to have a very good appreciation of the significant amount of work that has been undertaken over the past 10 to 15 years in this region, all within a non-regulatory framework. The stick has not been needed to date, and we haven't seen any evidence to support why it should be introduced with a heavy hand now. Taranaki Regional Council's most recent State of the Environment evaluation was undertaken in 2015. It will be being reviewed currently, and we look forward to the findings. It will be difficult to imagine anything other than positive outcomes given the concerted effort undertaken by so many different communities over the past 6 years, not least of all in the riparian management space. The Regional Council Riparian Management Program has 99.7% of the region's dairy farmers voluntarily committing to fencing and planting their waterways. As part of the program, almost 1,000 farmers were involved in the annual planting this year, which had over 1 million plants of 40 different species planted alone. So protection, maintenance and enhancement requires active and ongoing effort. If the focus is actually on the values of the sites, then it is the relationships and partnerships formed with landowners that will achieve the best outcomes for those values, not rules. Whilst many reason that rules shouldn't worry landowners if they don't want to cut the bush down anyway, that logic fails to appreciate that no one likes to be told what to do, least of all when they aren't going to do it anyway. That's human nature. And we heard some great examples yesterday from a range of different submissions, supporting that point. The fact is, too many rules are perceived to be barriers to action. They bring too many into the process and simply generate a money go-round, which could be better spent on the ground. When it all becomes too hard, inspiration is stifled, along with aspirational goals and action. It is well known that plant and animal pests are one of the biggest threats to Indigenous biodiversity. The predator-free Taranaki program has had more than 1,100 landowners signing up, with more than 6,400 traps covering 75,000 hectares going in since March. Coercion and compulsion cannot generate this kind of environmental response. The Taranaki Regional Council reports that this program will reduce predator numbers and have a significant impact on improving native biodiversity values. It will also inform the future direction of large-scale predator control projects across the country. This region's response to Indigenous biodiversity management is considered to be a leader for so many ways. We urge the Commissioners to resist pressure from parties seeking to change that for the hollow comfort that words on a page can provide. So that covers the issues that we want to highlight, but at risk of belabouring the point, if you do want a sense of how farmers feel about regulation that either doesn't achieve what it sets out to, or is trying to impose change at a speed and cost that is counterproductive, then we do ask you to reflect on the howl of a protest movement that it estimates over 50,000 people involved, but also perhaps more specifically with regards to SNAs, the most recent Far North Hikoi. The most surprising thing for me to surface out of these protests was how little people understand about Council Section 6 powers and responsibilities. It seemed to floor those in mainstream media that a district council can restrict use on private land for public good purposes, with many assuming that it must be a new concept or a new jurisdiction, because surely they would have known about such an affront to property rights previously. Now, clearly we know differently, but just because you can doesn't mean you should. That finishes my formal part. I'm not sure, Mark, whether you'd like to add any comment?
Sorry, I dropped out halfway through the call, but
You're sick of listening to me.
Just managed to get back in. No, just open to go to commissioners' questions. I think at this stage, but perhaps the only thing I would point out is the emphasis around the success in Taranaki that we have seen of a non-regulatory approach around biodiversity preservation and management. I think it's been a great success story, and there's a lot more that can be done there, but it highlights the advantage, I guess, of just having the right kind of incentives and drivers, I guess, in order to accomplish that, and ultimately that's what achieves the kind of biodiversity success stories that we have seen.
Thank you, Hilary and Mark. I will open the floor to questions, starting with Commissioner McMahon.
Thank you, sir. Okay, Ms. Walker, I'm going to keep this general because you've kept it general. It's just struck the panel that over the last day and a half, become apparent that some members of the community have misunderstood the rules and policy framework, and that's not a criticism, because as practitioners, I'm not sure that we've fully understood it anyway, but I'm just coming to terms with it. And I think, submitters like Mr. Barrett and Mr. Houghton this morning probably both acknowledged that there are aspects that they learnt about during the course of the hearing. Have you had a role in your advocacy in terms of explaining the policy and rules framework to the members?
Yes, and all I can say is, so fully appreciate the perception that you're outlining there. And I won't talk about individual situations because I don't know that this is necessarily going to help, but it is human nature, because I don't want this to sound like a criticism, but well, let me put it this way. When these are quite new and affronting subject matter for some people, although I do appreciate others have been involved for a while. Sometimes it's hard to hear what you don't want to hear. Like I say, I don't want to make that sound like a criticism. It's just a human fact. So yes, and actually I will say, in my experience, members find it much easier or they're more trusting of what I may say that a plan, about what a plan means in a council staff member. That's, again, also just human nature. I'm considered to be on their side. I am on their side. And so, what I say, often what a Feds policy person or a Feds, leader says will be trusted more than a staff member of council. So yes, we have a role to play. I personally haven't been too involved in this Taranaki space because my colleague before me was heavily involved in the submission and through all of that earlier pre-drafting space, so I can't take any credit for where this plan's landed. I have talked to some members recently, and hearing it in a different way from different people I think has helped to land it more clearly, which is what's obviously happened over the last few days. But the concepts are really quite foreign to people, and as I say, we're involved in it daily, and it's still difficult to really, it's like sand through your fingers really when you feel like you've got a handle on it, and then you look at it again and you think, how have I either missed that or did I interpret that right? So that's just the nature of the beast. It's a bit long-winded way of answering it, but Feds policy people do on a daily basis talk to members about rules and plans and what options they have available to them. Okay. If that's a more succinct way of putting it.
Yes, I've got three other brief questions.
If I could just add in there, I think we have also an ongoing role in that space also.
Yeah, good point.
I think there's a lot more that needs to be done, and we will have an ongoing role in that space. Yes.
Good point, Mark.
Thank you. Just three other matters. One of the big takeaways for me during the course of this hearing has been the understanding that there's more than one way to achieve the objectives of the plan, and identification of SNAs in the district plan is one way, but there are legal protection through other mechanisms is also another, and Ms Macbeth has clarified that that's definitely intentional, and that she doesn't see any point in duplicating the provisions, and so for me that's been quite significant, and I just wondered, do you think that's been appreciated by the members?
Fully, and it's a position that from a Feds perspective nationally, we try and get into every single plan around the country with varying degrees of success. Yes. So, fully appreciate the understanding that has been taken on board by the council, and I can assure you it is really well received by landowners.
And it's underpinned by Section 32 of the Act too, as being an efficient approach to protection.
That's our opinion.
Yes. Okay. Second question I've got is, you would have heard my very garbled question to Ms Macbeth earlier about getting the policy right. Yep. I mean, rightly or wrongly, there's the reluctance to change the rules significantly, and there's reliance on the consenting process, providing that there's a policy framework for enabling consents to be considered on their merits. Yep. I know you haven't identified any specific relief, but is the Federated Farmers submission broad enough or specific enough to enable further policy relief in relation to farm activities?
Yeah, so yes, I did turn my mind to that, and I actually have to recheck, but from my understanding, the Fed's broad position and a couple of the broad submission points do relate to ensuring that existing use rights are codified within the plan. We don't like to rely on them outside of the planning process, although we know they're there. They are notoriously difficult to prove. So we do prefer to have what the types of activities that you consider to be normal and usual in a farming context, and within that existing use rights sort of ambit, I guess, to be codified into rules. Whether that can then come up the way that these policies, and I can see the effort that's gone into that policy 3, I think it is, to recognise that, and I understand that the intent is there to have that achieved. Yes. So I'm fairly sure we've got some good scope there, but
Yes.
Yeah, our submission was relatively light on specifics,
Yes.
which is kind of unusual.
Yes, policy 3 and policy 4 are going to be critical policies
Yeah,
going
they will.
forward. Yes. And the reason I asked that is that the panel might be mindful of providing some direction on that. And
Sure.
I don't want to say anything more than that because we haven't discussed that as a panel. So I'm just signalling that as a possibility. My final question is, in 2019, with the changes, the amendments to the RMA, I think it was 2019, there was this concept of farm plans, and I've never really got my head around what that was about, and whether that was an alternative to district and regional plan regulation, or whether it was coexisting with that, and how that affects the matters that are in front of us now. Is there any simple answer to that?
Well, I think it could be consulting on right now. To be honest, our team is split up into, I'm very regionally focused, and there are others within Feds that do look at those kind of broader national policies that are coming out of government. But my understanding is that they were...
Can I comment? Yeah, Hilary, yeah, you're right. I think you're on the right track there anyway, but yes, that the current farm environment plan review that MFE is doing is missions perhaps disclosed at the end of last week.
Okay.
And Federated Farmers submitted on that review of those farm plans, and this was what you have highlighted there was our biggest concern in our submission, was that there was essentially a double up, and it wasn't clear that there was a separation in terms of them being identifiable different planning processes.
Yes. Was that perceived double up at both the district and regional level and the farm plan level, or was it just with regional and farm plan?
Yeah, so I'd have to look at that detail, but definitely at the regional level, and I'm guessing that certainly where there was some kind of a consenting process for land use required, I guess that's the main area of concern. So primarily that's at the regional level, but if there was a consenting for land use requirement at a district level, then obviously the same issue applies.
Yes.
But are you also meeting with the industry with two different double ups within farm plans themselves, were you meaning? Or?
No, I meant okay. Was there a double up between the farm plans and the regional and district policy and consenting frameworks?
Yeah, right.
Yes.
Because our understanding was the intent was that the farm environment plans would provide an alternative planning pathway.
Yes.
But that didn't seem to be clear in the MFE review that was going to be the case. So that is an ongoing concern for us.
Okay, and so that's still a live issue?
Yes.
Yes. Okay. Thank you for that. That was all from me.
Thank you. Thank you very much. Commissioner Littlejohn, Kit, are you there?
Yeah. Nowhere else to go.
Touche.
We're spreading the joy further south every month, so don't worry. I see Waiheke wants to cede from the union now,
yes,
which is an interesting proposition. They want all of the mainland's money, but just not the people that go with it. Always been a problem with Waiheke. Look, I don't. One of the things that you've very helpfully emphasised is that from a I guess a layperson, I don't mean that in a derogatory sense, these things have got to make sense. And I mean, you really do emphasise to me that ordinary people reading the plans can still sometimes find these things quite challenging. So the point you've made about the way the spatial layer for the public access is provided for, it's something I raised earlier this morning, and it's something that I'm going to be talking to the commissioners about, because I think there's an opportunity to rationalise the way the Waterbodies, the eco chapter, the subdivision chapter and the public access chapter all deal with this particular issue around subdivision and various aspirations. But but it's something that we can't sort of address today, and it's not a question, but it's certainly something of interest, because I think there's an opportunity to really refine and rationalise that, so that everyone in the world knows exactly what is going to happen or not happen if they subdivide or whatever. So no, I just thank you for the candid way in which you express the views of the members. It's very helpful.
Thank you.
Commissioner Coffin.
Good afternoon. I agree with you with what you said at the start in terms of this might not be an expected submission from Federated Farmers. That was a little bit unexpected.
Yeah.
But it was also refreshing that from your perspective as a member organisation, that you were comfortable, that's what I understood, you were comfortable with the approach that the council has taken in the preparation, development of the plan, and then working through the issues as we go, knowing that, understanding it's a statutory process. I was just wanting to see, and so I had a number of questions prepared, going right down to the detail of the Section 40A report. So I think we're going to put those to the side for today.
Okay.
But perhaps I'd be interested in getting a view from you in regards to the usability of the plan, because it's online. It's spatial in the first instance, and then there's the link to the plan itself. And I don't know if you have had a look, or other members have had a look, to see check the usability. Does it make sense? Does it actually tell you what you need to know? And could it be improved?
Well, it's one of the first e-plans that that was landed. It took me a while to get my head around e-plans. There's a few now that I've been working on around the country. So with use, I have become more familiar with the format and more understanding of it, and see the merits in it. With all the various hyperlinks and within the maps where you can put your property address in and have the big long list of rules that apply. So I think there is some really good usability that's been introduced with the planning standards and the format. But that's more around, I don't know that that's actually the question. If your question was around the actual words, within the rules.
I was more interested in the usability.
Okay, so then no, I think, it works well for me, but again, I do look at these a lot. So it's hard to have a perspective from individual, from what someone looking at it fresh would be. Except to say that, we do get members calling us a lot to say, what does this mean and what does that mean and how do I find out this? So, but of course that's why you're a member of Ed, so you've got access to that resource. But
So if I could just add an example there, obviously as part of this process, I actually put in a submission on an SNA for my property, which I was able to look up and access quite easily, and it gave me the information that I needed. And for me, the bigger issue here is perhaps rather than usability, it's getting people to the point where they use the thing in the first place, and that's where there might still be concerns. And so, for example, the SNA on my property, from a desktop exercise, it seemed to capture some areas that were not covered by a QE2 covenant, but in ground truthing, the practicality of the QE2 covenant meant that the SNA would be appropriate, and the officers have recommended SNA, so I haven't spoken further to it. But so the process there kind of all worked really well. But my concern is that we've still got members out there, or farmer landowners that haven't actually made access of the resources that are available, and there still will be some issues, some case examples whereby the SNAs have not been ground truthed yet, and there will be errors on the ground in terms of practicality of those.
Interesting. Okay, good.
But as I think this goes back to the original question that Commissioner asked around, Federated Farmers' role, and I mentioned that we would have an ongoing role. And I think, further farmer meetings and pointing them to both this resource and highlighting ongoing understanding around the planning process is going to be an important role.
I've made an assumption that farmers will have a good access to the internet, but I just wonder further to that, having internet access is one thing, but actually being able to navigate these documents at the speeds required in real time, whether that's, if you've heard that's an issue?
Yeah, well, Federated Farmers' own survey information around connectivity certainly shows, a large proportion, a third of rural users still operating at the 0 to 5 megabits per second kind of operating speed, or less than 20. I can't quite remember the numbers, but at that low end of the spectrum. So yes, there are some challenges in that space. I haven't heard of any specific examples, but in general, there are concerns in that area.
Yeah, I've been involved with a few e-plans in the past, and sometimes you really focus on the quality of them, and then when you go to check whether people can actually use it, that becomes very difficult. So trying to strike that balance between having the sophistication of the plan, but also making sure that people can navigate through it quickly is really important. Yeah, thank you.
Thank you very much. I have 3 questions. The first, and you're happy for either or both of you to answer. The first question is about, it's really about the infrastructure within Taranaki for this incredible replanting program or planting program, 1 million trees in 1 year, native plants. I'm presuming that there must be nurseries and a whole network of infrastructure that's just grown up around. My observation, as I said yesterday, was Taranaki's got this special feel about it because of that work that's been done over the last 15 to 20 years. I was just interested in the infrastructure and the eco-sourcing, and how does that all work?
Yeah, there is a really good system, and it is driven by the regional council land management officers, who are very early in getting out onto farms and getting orders and plans confirmed so that those orders can get through to the nurseries. And there is a good network of nursery depots around the place. And so it has built up over time. Over the last recent years, we've probably been doing around 600,000 plants per annum, probably averaged 500,000 per year for the whole of the decade. So it's been an escalating kind of program over a 20-year period. And this year, with the advent of funding through Jobs for Nature, that's what's enabled us to make a further step and pushed up to the 1 million plants this year, which seems to have been managed quite smoothly. The only problem has been that the contracted planters got locked down for a period, and so they're running a little bit behind schedule. But otherwise, the infrastructure is good, and the capacity seems to be there to do that on a sustainable basis.
Thank you for that. That was quite a practical question. The next question is around some other submitters, DOC and Forest and Bird in particular, requesting this, I would call it this residual district-wide catch-all rule. We had evidence yesterday from Mr. Shaw and Ms. Herbert that the SNA identification and protection has been very thorough. There's probably not, in their views, we heard as expert evidence that there's probably not a lot to mop up in terms of what a district-wide rule would deal with. I just wanted to get your experience and your knowledge on that and your view on that position.
Can I answer that, Mike?
Yeah, go.
God, because I have given that some thought. Because actually, to be honest, it was really exciting and encouraging to hear from the experts yesterday to have that level of confidence in the identification process. I probably haven't heard that before in the different districts that I've worked with, and have had some real frustrations with general clearance rules that get proposed with incredibly low thresholds, like the one DOC has got on the table, which we can be very clear about was absolutely not supported by us. The point that I'd like to make about it is that if there is residual risk, which I think we can all accept there will be some degree of residual risk, having that risk borne by a number of other parties and by so stakeholders, the council, public, DOC, iwi, stakeholders with a real vested interest in Indigenous biodiversity, having some of that risk borne by them, so not by the rules and then directly only by the landowner, I think actually is exciting. It helps to add, it helps to sharpen the focus, and it helps to prioritise the work that is about relationship building, and it is outside the district plan, which are mechanisms that are already in place and are identified as being part of the suite. I like the fact that there's some residual risk being borne by a broader group of people than just directly affected landowners, because I think then it's easy to get lazy and complacent and assume that that the risk won't escalate, I guess, and that's probably what I kind of would want to say about that. But
yes.
Did you want to add anything, Mark? Or
no, that's good.
Look, my last question is really about the strong message we're getting that this plan-making process has been a very useful exercise for the whole district and the whole community. When we briefed the councillors before we started the hearings, there were some questions to us about, with the uncertainty of maybe some new acts coming along, should we just can it and start again? And my observation from just looking at the submissions, the general levels of support, the strong landowner involvement, the strong iwi involvement, the relationships that I could see have been built, I said to them that, look, to me this is a Generation 2 plan on steroids. It's a Generation 2 plus 1 or whatever you want to call it, because as we've heard as a panel from the staff, they are thinking ahead and anticipating the way that public policy is going and trying to accommodate that within scope as much as possible. So really it's just a question about, we're into it anyway, so just the general support for just carrying on and just getting this plan done, I think will have a long legacy. But I just wanted to understand whether you agreed with that proposition.
Yes, I do. In principle, I think we're far too far along to throw it away. I guess my only caution around that is there is some concern that we've felt about the desire to have it perhaps a bit more future-proofed than what it needs to be at this time. There is so much uncertainty ahead of us, and as I sort of alluded to with the point about some of that exposure draft stuff that's floating around, it's just, I guess, easy to pick the goals that are the ones that make the most sense to some people, rather than really having those policy documents in the round. So I guess that's all I would add about that. That that there is some caution that I think needs to be applied until we really do have some certainty around what the future of some of our resource management is going to look like in New Zealand.
Yes, and you would have heard that my line of questioning and the panel's line of questioning, that we have to deal with the high-level documents that we have, not what we might have in the future. Yeah. And from a decision-making point of view, it's absolutely crystal clear we are dealing with what's on the table as policy. The one that's come in during this process has been the NPS FM 2020 and the concept of Te Mana o Te Wai, and a strategic direction sense. That's actually found its way into the strategic direction objectives, but that's has been on the table, and we have heard there's scope to include that. So these other ones, the Indigenous Biodiversity NPS, what may or may not happen in terms of future changes to the law. I'm not suggesting that the planners are trying to anticipate that. It's just really the general direction of the way planning is going in terms of public policy and also public expectations, because the plan does need to reflect the community's aspirations. That was just a comment there, but I thought that was certainly your submission sort of confirmed to me that there's been a lot of good work done which does need to be captured.
Yeah, I appreciate that.
Yeah, and I think would agree. And obviously the NPS Indigenous biodiversity is kind of a good example of that, because it's created a heightened level of interest amongst landowners, and I think that comes back to one of those key points here around our ongoing role in terms of understanding. And obviously it was appropriate for this plan to be able to continue to proceed, because it's already backed by considerable case law, I guess, in terms of what's been the history of FNAs in this district. And I think that's important for our farmer members to kind of get a good understanding of that, rather than thinking that perhaps that's going to significantly change the situation once that NPS is fully released.
Thank you. Well, that's all we have. I appreciate the attendance as always, and just sitting, listening as well, Hilary. I think that's really helpful. That you've got the context of the other submitters, which for a regional organisation is quite important. So
it is.
Appreciate that, and thank you very much, Mark.
Thank you. Thanks, Mark.
We'll see you again in future chapters, I'm sure.
Yes, definitely.
Okay, thank you. Thank you. Well, it's 1:30 and it's been a long morning. I think we should take 45 minutes and return at 1:15. Well, sorry, 2:15. Gosh, I've lost an hour. Yeah, there we go. 2:15. Thank you.
Stinky.
Oh, yo.
Eyes going up and down, so that's good.
Welcome back, everybody. I think we've started recording and we're underway. A slight change of order in terms of the schedule. I think we're going to be talking with our Taranaki Regional Council people later in the afternoon. And so, Port Taranaki, Ms. Carter, welcome back. How are you?
Welcome. Thanks very much.
Yes.
Yeah.
Do we have Mr. Dingle online as well? Yes, I can hear you there, Ross. Thank you.
Good afternoon, everybody.
So yes, I think we'll start with you, if that's all right.
Yes, I think Mr. Dingle could go first and set the context for the port.
Sure. Thank you.
My name's Ross Dingle, and in my summary of evidence, I've given my qualifications and experience and role, so we'll take that as read, and I'll just move straight into the body of the submission.
Thank you.
So just to start with some context around port land and the overview. So Port Taranaki is a breakwater port. The port's the only deep water port on the west coast of the North Island of New Zealand, in fact, of New Zealand, and it occupies a very strategic location on the coast connecting New Plymouth with the rest of New Zealand and international markets. In total land size, we have 65.9 hectares, and a part of that, 18.8 hectares, was purchased from the former Contact Power Station in 2012. That is shares a boundary with Mikatahi Rock, and is also part of the main port activity area, which is Area A under the proposed district plan. In terms of trade characteristics, we consistently exchange over 5 million tonnes of cargo annually at Port Taranaki, over 9 working berths. 80% of that export volumes, and a very large portion of that is bulk liquids. But we also have growing volume of logs and a fairly consistent volume of agricultural feeds and fertilisers supporting the region of Taranaki. We have 450 to 500 vessel movements per annum, of which about 265 to 300 vessel movements actually supports that 5 million tonnes of trade across our wharves. On an overall volume basis, Port Taranaki is the third largest port in New Zealand, making it very important for the region and the nation. And that statistic comes from the Deloitte New Zealand Ports and Trade Yearbook for 2021. The former Contact Power Station site retains national power grid connections up until early 2020, and with the release of this constraint, so that the connection to the grid has now been completely removed, that allows us to proceed with development in that area, which of course we know is the boundary on the northeastern perimeter of the site that neighbours Mikatahi Rock. In terms of the economic contribution of the port, so there was a study completed by Burl in December 2017, and that study said the port itself and the activities associated with it account for output of almost $800 million, value added of a little less than $400 million, and full-time equivalent employment of almost 1,250, which is significant for our region. The port has grown its shareholder returns in recent years and increased dividend payments to its shareholder. The payment of dividends support regional activity and has the effect of reducing rates to all Taranaki ratepayers, householders and businesses alike. In terms of the changing nature of trade of Port Taranaki, so bulk liquid trade associated with the region's oil and gas resources, the most significant trade sector for Port Taranaki, and the levels of activity around that are really aligned with the risk profile in this sector and economic drivers which kind of justify investment. Historically, the focus for the port has been to service export activity, and in the past this has included studies to develop facilities to export LNG from the port. The 2018 ban on new offshore exploration permits has changed the balance of potential resource available beyond the next decade, and resource consumption alternatives could support domestic energy services or manufacturing, including that for export through the port. So some examples of how Port Taranaki may need to adapt to accommodate one or more of the following scenario. To adapt, I can explain in one or more of the following scenarios. So there's the potential development of an LNG import terminal connected to New Zealand's energy pipeline network through Port Taranaki. So the port itself is very well connected with the New Zealand energy pipeline network. Development of a renewable energy production facility on the former New Plymouth Power Station site, facilitating the trade of liquid hydrogen and or ammonia to world markets. Consider expansion of log export operation through development of additional laydown areas and road connections from road to wharf and from rail to wharf. We can't rule out the possibility that the economic environment may reset container traffic settings to the extent that Port Taranaki could become another part of the container logistics supply chain in the country as well. Bulk dry will continue to be an important import into Port Taranaki to support the regional dairy economy, but also some of the products may change. In terms of future expansion and potential demand, the Contact Power Station site has significant potential for the port. The 18.8 hectare site can be developed to accommodate a range of existing and future operating modes to meet potential customer demand both currently and into the future. The company has entered discussions with multiple parties over the years to further develop the site to support potential import and export markets. To facilitate these discussions, Port Taranaki must have the ability to develop infrastructure near Mikatahi Rock that will ultimately support regional significant trade to and from the region. On the site itself, animals' feed is currently stored there. It's been used for scrap. It's been used for various other products coming through the port in support of oil and gas and project cargoes. We were in discussions with Project Huakai, which is another significant Taranaki regional initiative. It's been publicly signalled by a US-based firm, 8 Rivers Capital. The port has been involved in preliminary evaluation and the role it could play to support this major opportunity. In October 2019, the developer stated that production potential of 200 million kilograms of hydrogen and 2.1 million tonnes of urea existed and the creation of an enormous export industry. The full development of this regionally significant export opportunity would likely require product passage via pipeline or roading around or near Mikatahi Rock without affecting Mikatahi Rock's physical or geographic characteristics. The region's plans for a low-carbon future and explores opportunities to develop a green renewable energy future. Then Port Taranaki is the obvious connection point that can transport that energy from the region to other parts of New Zealand and to world markets. The former New Plymouth Power Station site is ideally situated to support Taranaki's new development objectives. This could be pipeline construction close to Mikatahi Rock, to transport product from the New Plymouth Power Station site towards export. I'd like to also now just quickly focus on the recognition of tangata whenua. So our operations respect the environment we occupy and depend on good relations with the community. The port's relationship with the neighbours, including Ngāti Te Whiti, Hapu and Ngāti Te Whiti Whenua Taupu Trust, is important. Our operations fall within the rohi of Te Atiawa and borders the Taranaki rohi. The New Plymouth District Council also participates in the oversight of the Ngāmuti Beach area with the port and Ngāti Te Whiti through the Port Areas of Mutual Interest, or PAMI Forum. This group has a range of forums, formal and informal in nature, where the aspirations of each are shared and resolutions of issues achieved. Port Taranaki, as the landowner, recognises that Mikatahi Rock is a culturally significant waihi tapu site for Ngāti Te Whiti. Our association with Hapu is long and an enduring one. The link to Mikatahi is strong, and there is a strong desire within Port Taranaki to ensure that Mikatahi Rock and its cultural values are recognised and respected. This has further been demonstrated through our partnership with Ngāti Te Whiti, where they endorsed the naming of Port Taranaki's pilot vessel, Mikatahi, in 1994. Port Taranaki and Ngāti Te Whiti are working together in partnership to explore new ways of enhancing consultation and providing new ways to inform and educate Port Taranaki of the areas of cultural significance within the port zone. To further enhance this, Ngāti Te Whiti has completed a cultural values framework, and the parties are working together to develop a kaitiaki forum. The parties have also agreed on a process ensuring Hapu members can gain safe access to Mikatahi Rock as required, and that example is included in Appendix 2. So in conclusion, I do not support the submission of Ngāti Te Whiti to amend Schedule 8 and 10 and the planning maps to include Mikatahi Rock as part of Paratiri Ngāmuru, Shukalove Islands and Kapua natural feature and landscape and outstanding natural character areas. I consider that Mikatahi Rock is already adequately protected under the proposed district plan. Any substantial development within the area would be subject to consenting process. The current classification has been integrated into our mode of operation, so there doesn't appear to be a driver for change. There has been insufficient consultation with Port Taranaki and adjoining landowners and lessees in arriving at this proposed outstanding natural feature landscape classification. Port Taranaki works with the community, importantly Ngāti Te Whiti, to provide access to this waihi tapu site. I consider that the proposal to change the classification to an ONFL could potentially risk over-regulation and limit Port Taranaki's ability to secure regionally significant opportunities to facilitate trade from the former New Plymouth Power Station site. Mikatahi Rock, in my opinion, should not be included in Schedule 8 and Schedule 10. Thank you very much.
Thank you, Mr. Dingle, for your evidence. Just a procedural matter before we ask questions. We did raise, or Commissioner Littlejohn did raise at the start of hearing 5, that he has declared a potential conflict of interest around his involvement with the port previously, and will not be sitting on the special purpose port zone hearings. He's stood aside, and that's been with my my approval. Because we weren't alive to this issue before we read the papers, we've just made a decision as a panel that Commissioner Littlejohn won't be involved in deliberating on this particular matter, and he won't be asking you any questions. So there'll just be three of the panel members dealing with this particular matter. We've done that quite often, just with discrete issues on other zones. So I just wanted to make everyone clear of that. So Commissioner Littlejohn will be listening in, but will not be involved in the discussions. I do have a few questions of you, but I'll start on my right with Commissioner McMahon, who may have some questions.
Good morning. Oh, sorry, good afternoon, Mr. Dingle. Can you hear me okay?
Yes, I can.
Good. Look, I just have one question for you, and I'm going to go right to the crux of the matter, and it relates to your very last two sentences on your statement. Where you say you consider that the proposal to change the classification to an ONFL could potentially risk over-regulation and limit the port's ability to secure regionally significant opportunities to facilitate trade, and that Mikatahi Rock should not be included in Schedule 8 and 10. My question is why? Why do you believe that the scheduling of Mikatahi Rock would lead to those outcomes?
Well, I think that Mikatahi Rock's already adequately protected as a site of significance to Maori and as an archaeological site. And I just don't feel that it needs another layer of regulation put on a piece of land that's that's owned by Port Taranaki and runs the risk of requiring us to go through more process to develop in and around that site.
Okay. In saying that, are you aware that the rock is, or you are aware that the rock is listed as a SASM and has an archaeological overlay over it also?
Yes, I am aware of that.
Are you aware of the regulations associated with those two overlays?
I'm not intimately aware of that, but maybe Janice can comment on behalf of the board.
And we'll have some questions for Ms. Carter on that, but in the meantime, would you consider that there's a potential for the existing overlays, the SASM and the archaeological listing, to actually also have the same outcomes that you've identified in the last two sentences of your statement?
I believe that that is a potential, yes.
Yes. And if that's the case, if I suggested to you, and I'll just check with Ms. Macbeth first before I put this question, sorry, Ms. Young. Ms. Young, as I understood your report, there's no rules associated with this listing, is there?
No, I didn't recommend any rules.
No.
There's no rules with the, because it's really just joining it back up to Paratutu.
Thank you.
Yeah.
Thank you. So Mr. Dingle, if the panel were to recommend the inclusion of this feature in Schedules 8 and 10, it wouldn't bring any new rule requirements with it. Did you was that your understanding prior to today?
Yeah, look, as I said, I'm not. I don't know the intimate details of those requirements.
But what I'm putting to you, though, Sarah, is that if there are no new rules and there are existing rules that you say or accept could frustrate the activities of the port, why is the inclusion of the feature any different from what's been proposed in the notified version of the plan?
Yeah, I guess, is there a risk though that future rules could be applied to that classification that might not be applicable to the current classification?
Okay. Well, I can't discount that, but what I can say to you, and what I said to an earlier submitter on the very same issue in relation to SNAs, is that if there were to be future rules, there'd be a public process associated with that, which would afford you and other submitters an opportunity to be involved. So I think we can put that to one side. I'm just trying to understand why you've made a categorical statement in your last two sentences that there is this potential to frustrate the objectives of the port by the inclusion of this item in two schedules when there's no additional rule framework.
Yeah, so I guess what I'm saying is that we believe that there's enough regulation around the current classifications without having to muddy the waters by putting a new classification on top of it as well that we have to consider.
Okay, I understand your position. Some people might suggest that the converse of that, well, what odds of adding another regulation or another policy framework around that if there's rules in place already? I mean, what would your response be to that?
Well,
particularly if the new framework related to a different imperative. So the imperatives at the moment are around Maori values and archaeological values. This is around an outstanding natural feature and landscape, so a different imperative. Wouldn't it be more appropriate to consider all three imperatives?
Yeah. I guess when I think of Mikatahi, it's quite a small hill. It's been highly modified. I don't necessarily classify as an outstanding natural feature, albeit I do recognise that some experts have recommended that it should be.
Yes. Okay. My final question on that is the port isn't leading any evidence challenging its significance as an outstanding natural feature. No expert evidence anyway, is it?
No.
No. Okay. Thank you.
Thank you. Commissioner Coffin.
Oh, good afternoon.
Good afternoon.
Just had some questions. You put forward, and it was quite helpful in regards to some of the future potential activities that might happen in the port, and you gave some detail about those. Would it be safe to say those are future potential activities that the port's thinking about that may directly affect Mikotahi? That's the context in which you've put those forward?
That's correct.
Yes. And so would you accept that those activities potentially would affect the physical nature of Mikotahi?
The physical nature.
Like I'm thinking there may be further modification if you were looking to progress some of those activities. There may be physical disturbance or modification of.
No, the port does not intend to disturb or modify Mikatahi further. So the port recognises the importance of Mikatahi to Ngāti Te Whiti.
Yes.
The cultural importance, and would work with Ngāti Te Whiti to ensure that we're not modifying Mikatahi further.
So what would be the effect of an ONFL classification then if you didn't have any intention to physically disturb Mikotahi? Is it a fear, or is it a concern that works near Mikotahi, or other things activities in proximity might be affected?
It's proximity. It's in and around Mikatahi. There's a concern that our ability to provide infrastructure to support customers present and future could be denied because of this status.
You gave us a bit of a précis of how important the relationship with Ngāti Te Whiti and Te Atiawa is. I thought that was quite articulate. Could you give us an update of where you currently are with Ngāti Te Whiti? You said there's an access agreement. Is there any other types of agreements or any other types of arrangements?
Yeah, so you'll see in my evidence and in Ngāti Te Whiti's evidence that we've developed a cultural values, or Ngāti Te Whiti has developed a cultural values statement, and we're working through implementing aspects of that statement. The part one was to set up a kaitiaki forum. The inaugural meeting for that kaitiaki forum was on the 2nd of September this year. Unfortunately, because of COVID, it had to get postponed. So we're just trying to establish a new date for that. But our intention is to have that session and develop a terms of reference for a kaitiaki forum, including who should be involved, how often we should meet, and specific topics to review through that process. So, and that's been worked on with complete cooperation between Port Taranaki and Ngāti Te Whiti, and supported by Te Atiawa.
Well, thanks for that. How does the access arrangement work? You said in the submission and the evidence is access arrangements. What's the practice of that?
Yeah, so at any point that a member of the hapu would like to visit Port Taranaki, they need to notify Port Taranaki, because they are accessing through a port operational area, which is subject to some international standards about who can and can't get through the port. And so once we've got that request, then we facilitate getting them through the port so that they can access Mukatahi.
Have any requests been made thus far?
There's been very few, to be fair. I've been at the port for 2 years, and I think there would be less than 5 occasions where we've been asked to use that that process to access Mukatahi.
And what was the outcome of the requests? So I don't know very much about the port operations, so just assume I know nothing about it.
Yeah, what I can say is that each time that Ngāti Te Whiti has requested to gain access to Mukatahi, they've been granted that access with facilitation from Port Taranaki.
So just turning my thoughts back to the ONFL, excuse the acronym, Outstanding Natural Features and Landscapes. Do you consider that the values that underpin the ONFL are different to the SASM values? So for instance,
I'm going to have to revert to Indigenous to answer that question for me, I'm afraid.
Okay, thank you.
Thank you.
It's not an area of expertise for me, I'm sorry.
No, that's fine.
Thank you, Mr. Dingle. I I read in interest the Appendix 2, which is the access agreement, and the example of the hazard in the area is seals. So obviously it's an area that wildlife do frequent. So
absolutely.
That's interesting. Look, I do have a few questions for you, more general questions. Just who is your shareholder?
Taranaki Regional Council is our shareholder.
Yes. Thank you. 100% shareholder by the Regional Council.
Yes.
I am interested. I'm working on these matters in other areas about the possible hydrogen production or green hydrogen production, ammonia, and export possibility. What is the renewable energy that's being thought about for making that hydrogen?
So at the moment, you could put a hydrogen production station in the area, accessing power from the national grid, which can be considered green. But more importantly, the discussions that we're having with potential users of the site would be of such an extent that would facilitate the development of some offshore wind parks off the coast of Taranaki. And Taranaki is actually particularly well suited for that because of ocean depth, wind patterns, and of course proximity to a deep water port that can support the ongoing operations of an offshore wind park. So it's about connecting a number of dots, and that's actually been done through the Taranaki 2050 roadmap. And what I would say is, I can't go into detail, but there's certainly a lot of really productive discussions going on with global players in the renewable energy space, both whether it's ammonia or hydrogen and renewables, wind, that could provide some real benefit for the Taranaki region, and certainly opportunities for Port Taranaki.
Yes, and I think I'm interested in that because, as I say, I'm involved around the country in these matters, and just understanding that it's perhaps an offshore wind source rather than something actually on the land in the vicinity of the port that might drive the renewable energy. It's energy either from the grid or from a new renewable source. So that certainly makes a lot of sense. So thank you for that. The Puakai project, which there was some press about a few years ago, is that still proceeding, or is that confidential in terms of what people know about that project?
So that project is no longer proceeding in New Zealand. It's now proceeding in the United Kingdom. So we lost the opportunity.
Yes. Okay. Thank you for that. It was something I was interested in. Now, Port Taranaki being the landowner, so this is land that you bought when you bought the old Contact Energy thermal power station site. Mokatahi came with that purchase. And is that right?
I'm not sure that's correct. I think Mokatahi is part of the main port area.
All right, so it was already owned.
I believe so. But like, if I look at the New Plymouth District Council map and I click on the New Plymouth Power Station site, I don't think it includes Mokatahi. I can check. Yeah, so the New Plymouth Power Station site is 151 Breakwater Road, New Plymouth, and that does not include Mokatahi. Mokatahi is included on 198 Breakwater Road, which is the main port area.
Okay, so that's been held. So while you have that plan up, I wanted to talk to you about your Appendix 1, Mr. Dingle.
Yes.
Which I found quite an interesting figure, and on those 5 tanks there, are they currently operational, or are they part of the old power station facility?
Right, so the 3 tanks closest to the water are part of the former New Plymouth Power Station facility.
Yes.
The tank on the left holds about 400 tonnes of heavy oil. The tank in the middle is currently used by Road Sciences to hold bitumen, and the tank on the right is not used at all.
Yes.
The 2 tanks that are inland from those 3, that site is a piece of land owned by Methanex, and that is the Methanex terminal, which is a major hazard facility, and that is not owned by Port Taranaki.
All right, this geography is really, really useful. And on your Appendix 1 figure, you've blown up that area, and you've got Methanex terminal. There's 2 tanks here. The hazardous is the red line or the orange line around that facility. Is that the land area, or is that the hazard zone, or what is that?
That's a land area. That's a parcel of land.
Okay, and we can see that area in that most northerly tank is very close to Mikatahi, isn't it?
It's very close.
Would it be a matter of 20, 30 metres or?
I would need to check.
Yes, okay. It's very close.
It's in very close proximity.
Okay. No, look, that is fantastic. Thanks for just clarifying those matters. And I have no further questions. Appreciate your assistance.
Thank you.
I think Commissioner Coughlin has another supplementary question.
Just thought if you could give us some further background in regards to the engagement that the port has had in regards to Mikatahi being proposed to be included in the schedules. Just I'm taking from the submissions and the evidence of Ms. Carter was that there's been minimal effort to engage with the port, and I just wanted to you'd be able to articulate that, please, for me.
Yeah, so we had a one phone call session with the planner in regarding this, and it was our recommendation through that process that it not be included. But I guess there's other parties potentially involved here, e.g. Methanex, and through that process we also were interested in making sure that there'd been appropriate consultation with Ngāti Te Whiti as well as part of this recommendation.
Thank you.
Just prompts me a follow-up clarification for the staff. Methanex are not a submitter on this particular point, is that right?
That's correct.
Okay, thank you. Thank you, Mr. Dingle. We'll ask Ms. Carter to present her evidence now. Thank you very much.
Thank you.
Yeah, thank you, Commissioners. Like Ross, I will skip a couple of pages of my evidence and take those as read and go straight to the submission of Ngāti Te Whiti and Port Taranaki through the submission. And
page 3, is that right?
I'm starting at paragraph 16 on page 3.
Thank you.
Ngāti Te Whiti Hapu Society have requested that Mikatahi be included in Schedule 8 and 10 on the relevant planning maps. As part of the
Sorry, can I just interrupt?
Yes, sure.
We have pre-read your evidence.
Okay.
As set out in our hearing schedule. We have asked for a concise summary to be presented. If you haven't got one in written form, just for the efficiency of the process, we have read thoroughly. We have a number of questions. We don't require you to read through your evidence,
Okay.
but if there are some key points you'd like to pull out, that would be convenient. Thank you.
Okay. So in terms of carrying on, I wanted to point out the higher order documents that are relevant to this, being the New Zealand Coastal Policy Statement, outlining policies 6, 9, 13, and 15 as being key in the discussion that we have before us. And I've included those in paragraphs 22 to 29 of my evidence. In terms of policy 6, activities in the coastal environment, policy 9, ports, policy 13, preservation of the natural character, and policy 15, natural features and natural landscapes. In terms of the interpretation section of the New Zealand Coastal Policy Statement, it states that the numbering and the order in the New Zealand Coastal Policy Statement is not to be interpreted as an indication of relative importance. So in my opinion, this confirms that no one policy has precedence over another. And so when read together, it's not necessary to identify Mikatahi as an outstanding natural landscape to ensure its current values are protected. And in my opinion, the other mechanisms proposed in the PDP give effect to these policies. I also consider it's important to recognise that ports have a functional need to be located within the coastal environment, and that this is appropriate to continue to provide for Port Taranaki in its existing location to give effect to policy 6 and 9. And I also want to stress that inherently ports must be located in the coastal environment. Port Taranaki is an established port, and Mikatahi is set in a highly modified environment. Protection of this feature already occurs through identification of Mikatahi as a site or an area of significance to Maori and as an archaeological site. Now, the site is also located in the Coastal Environment Overlay, and the provisions of the Coastal Environment Chapter apply. So overall, in my opinion, the existing PDP provisions are adequate to ensure that the feature itself is protected from inappropriate development. In terms of the Taranaki Regional Policy Statement, there is a number of policies there that I identify in my evidence, and I won't go into those in detail. I draw attention to INF Objective 1 and INF Policy 2, provided at page 9 of my evidence.
Thank you.
Okay. There's also section 8.1 of the Taranaki Regional Policy Statement, which talks about the natural character of the coast. And policies CNC Policy 1 and CNC Policy 2 focus on the protection of the natural character of the coastal environment. But also CNC Policy 3, Port Taranaki, states appropriate recognition should be given to Port Taranaki, ensure its efficient operation, and enable appropriate development and diversification to occur to meet changing needs. I turn now to the Section 42A report and some of the comments that I've made in my evidence with respect to that. At paragraph 220, the reporting planner describes the provisions of the port zone to be largely permissive. Overall, I'm not confident, as confident as the reporting planner, that the plan is permissive in respect to the port, particularly when we take into consideration some of the large new projects that Mr. Dingle has spoke about. Consents for such projects at the port are likely to be combined land use and coastal consents, where a bundled discretionary activity status is more likely. And also too, the numerous layers that must be considered in addition to the port zone make the discretionary activity status more likely. In terms of policies, policy NFL P2-1A does create a high bar for new activities locating near outstanding natural features and landscapes. So I'm not talking there about within, I'm talking about close by. A new facility proposed at the port, which may already be contentious from a public perspective, such as a hydrogen facility described in Mr. Dingle's evidence, will have a more onerous consenting pathway. Now, this is because NFL P2-1A is an avoid policy, which refers to any adverse effects, whereas NFL P2-2 allows for avoiding, remedying, or mitigating where the adverse effects are not significant. Consequently, the second part of the policy is less onerous. The difference between being required to avoid any adverse effects in NFL P2-1A in comparison to being required to avoid significant adverse effects in NFL P2-2A is material difference when considering the consenting risk for the types of projects described by Mr. Dingle. I'll now move on to consultation. At paragraphs 61 to 63 of my evidence, I outline the consultation in respect to this matter. And I reiterate that, in my view, in terms of processes like this, such as an outstanding natural landscape being included in a plan, the consultation has been minimal. I also want to express that the decision to recommend inclusion of Mikatahi within the Paratutu, Ngā and Tupane natural feature and landscape and outstanding character area to be premature and not in accordance with the Council's usual processes on these significant matters, particularly given that PTL, or Port Taranaki Limited, is the landowner. Mr. Bain himself acknowledges in his evidence that Mikatahi is not included in the Taranaki Regional Council's regional landscape study, and there's been no district-wide assessment undertaken. So overall, I consider that minimal effort has been made to consider the proposed inclusion of Mikatahi from the perspective of the impacts on significant regional infrastructure such as Port Taranaki. The port requires a coastal location, and Policy 9 of the NZCPS and CNC Policy 3 is required to be given effect to. Overall, I consider there are other means to protect Mikatahi, which have already been included in the PDP. These other means are more appropriate, in my opinion.
Thank you. Thank you very much for that summary. We'll start with, is there anything else you'd like to add just before we have questions?
No, that's fine.
Thank you.
Questions now, thank you.
Commissioner McMahon.
Good afternoon, Ms Carter.
Good
Can you
afternoon.
hear me? Can you hear me okay?
Yes, I can hear you fine.
Good, thank you. This is an interesting one to state the obvious. I just wanted to focus initially on the higher order documents, particularly the coastal policy statement and the regional policy statement. And I take your point about no particular primacy between the policies and the NZCPS. We can't take anything from the ordering of them, so that's a point that well made. In relation to policy 15, however, I just wonder, is there, and particularly subclause C and D of that policy, which requires the identification and then the protection through RPSs, plans and maps, etc. Is there any other course of action open to the District Council other than to identify and include this feature in the schedule if it meets the criteria outlined in subclause C? I mean, you've acknowledged in paragraph 21 that the district plan must give effect to the coastal policy statement. If the feature qualifies in terms of 15C, aren't the council duty bound to include it in their schedule?
Yeah, that is an interesting question as to whether, when you balance up all the various things and taking into account the other policies, whether policy 15 directs, does policy 15 direct that it must happen? In my view, it doesn't direct that it must happen. It basically says ensuring that regional policy statements and plans map or otherwise identify areas where the protection of natural features and natural landscapes requires objectives, policies and rules. So my position really is that it doesn't require it to be identified as an outstanding natural landscape with the associated policies and rules associated with that, but that otherwise identify areas and ensure that there are means of protecting it. And what I'm arguing here is that they're already scheduled in terms of possessions and also in terms of an archaeological listing as well. And there's other rules in the plan. I think it's also an identified feature. So there's a lot of layers in the plan. It's also subject to the coastal environment. So there's other objectives and policies and rules in the plan that protect Mikatahi. And so that's the thing that I'm taking, that when you weigh up policy 15 with policy 9 and perhaps even policy 6, that you can come to a conclusion that so long as it's protected, it doesn't necessarily have to be identified as an outstanding natural landscape.
Yes, I certainly acknowledge the other forms of protection that you've outlined. I don't think they are in dispute. How would that argument sit, though, if the SASM and the archaeological site weren't present and we were dealing with an archaeological feature that the port's not disputing and not leading landscape evidence on to say that it doesn't meet the criteria in the NZCPS? So in the absence of the other protection, wouldn't the council be duty bound then to include this feature in Schedule 8 and 10?
I mean, that it could be. Looking at the list of items in policy 15, one of the items is cultural and spiritual values for tangata whenua,
Yes.
which have been recognised as part of the schedules. So in there is, I don't call it a double up. I think it's an important part of identifying the whole landscape, that these issues of cultural and spiritual values are an important part of identifying outstanding natural landscapes. They're not everything, they're not the only thing, but in this particular case, because they have been identified as a site in the area of significance for Maori, I feel that that covers that particular aspect.
Yes, but you'd acknowledge also that there are other criteria, including legibility or expressiveness, that don't necessarily relate to cultural matters, but relate to landscape matters per se.
Yeah, I do definitely acknowledge that there's other aspects of this list that are relevant as well.
Okay. So just finally on the NZCPS, are you saying that reading policies 6, 9, 15 and 13 in the round would lead us to make a broad judgment on the need to include or otherwise this feature?
Broad.
Well, I mean, are you saying don't cherry pick certain policies like policy 15 and rely on it as the mandate for inclusion?
Yep, that's it. I just wanted to also mention, in terms of process, what might, if Mr. Bain references the quality planning website when he has gone through his assessment, and in that itself, it talks about taking an interdisciplinary approach to assessment. So I'm not disputing Mr. Bain's assessment at all. What I'm saying is, in terms of a process of going through and identifying outstanding natural landscape, it talks about appropriate skills being natural science, cultural, statutory planning, all being part of the process of identifying outstanding natural landscape. It also talks about appropriate consultation, engagement with the community and relevant landowners. And it also talks about professional judgment, ideally more than just one person should be involved in the assessment, and ideally it should be peer reviewed. And while I don't take exception to Mr. Bain's assessment myself, because I'm not a landscape person and I'm not in a position to peer review it, I noticed that no one else has peer reviewed it. So in my view, there's just not been enough work done to identify this as an outstanding natural landscape. So I'm not querying Mr. Bain's expertise in saying that.
Thank you. My second area of questioning relates to the Taranaki Regional Policy Statement. You've helpfully identified some of the infrastructure objectives and policies that relate to the port. In your preceding paragraph, you make some reference to some of the natural features and landscapes provisions, but you haven't identified what they are. I'm just wondering, are there objectives and policies in the regional policy statement that relate to the identification and protection of outstanding natural features and outstanding natural character areas?
So, so there's policy CNC Policy 1 and CNC Policy 2, and they do focus on the protection of natural character in the coastal environment.
Yes, can you just repeat those, Ms. Carter?
Policy CNC Policy 1 and CNC Policy 2. So they're in the chapter of section 8.1, protecting the natural character of our coast.
Yes, and presumably they have an umbrella objective for sitting above them?
Yes, they do. I don't have it at hand, but I'm quite happy to look it up.
No. And what's the flavour of that objective and policy approach in the RPS?
So in my view, it is about recognising that Port Taranaki, so I was just about to mention policy CNC Policy 3, talks about recognising Port Taranaki to ensure its efficient operation and enable appropriate development and diversification to occur. But that's in the context of also protecting the natural features of the coastal environment, but also takes into account that some infrastructure has to locate in the coastal environment.
Yes.
So that's, if you look at policy 1 and 2, you'll see that those things are intertwined in the list of matters to be considered.
Yes. But just going back to my question, what's the flavour of the objective in that section?
I think the flavour of it is in protection of the natural features, but also actually made a special consideration of infrastructure, and particularly it makes a special acknowledgement of Port Taranaki.
Yes, okay, thank you. And moving on now down the chain a bit to the proposed coastal plan, you've drawn to our attention that Mikatahi was not included in the notified version of the PCP and wasn't the subject of submissions. What should we make of that?
I'm just drawing attention to the fact that there's been a recent coastal plan process where the same outstanding landscape has been identified, and it hasn't been requested in that particular process to include Mikatahi. That's based on the fact that the Taranaki Regional Council's coastal landscape assessment also doesn't include Mikatahi. So the plan didn't come out with Mikatahi included. And when you look at a map of the coastal plan, it shows all the areas around Ngā Motu, Sugarloaf Islands, there, but specifically misses around the area of the port that's developed.
Yes. Ms Carter, what was the date of the Regional Coastal Landscape Assessment?
2015.
15. Okay. Thank you. Thank you.
I do have a picture of the area included in the proposed coastal plan, if you would like to share that screen.
Sorry, what was that?
You're gonna bring up a plan?
I can bring up a plan showing the identification of the ONFL in the Taranaki Regional Council's assessment, showing that it specifically goes around the Tahi.
Yes, please, if you could do that. Thank you.
Okay. Hopefully I can do this without plugging myself away. At the moment I've only got one screen, so I'll just see what I can do. Good moment. So does someone want to direct me to where the share, oh there it is, share screen. Yeah, I was using Teams. Here it is here. Can you see that?
Yes, we can, thank you.
Okay, so if you look at the bright highlighted area, that's got Namatu, Sugarloaf Islands Marine Protected Area. We've also got the Tupuai Marine Reserve, but the area in yellow is the outstanding natural landscape area. And if you can see, it includes Paratutu. I'll use my, I think I can use my, to the, just above the words New Plymouth, there's Paratutu is included. So it comes into the land and then goes back out to sea and goes around and doesn't include Rikatahi.
Yes. I can't say with confidence I can see that, but I take your word for it.
Oh, okay.
There's no reason to doubt it.
Yeah. Okay.
Could I just ask, because you can see the map clearer than we can, are there any landward sections included in the outstanding natural landscape?
Yes, so if you look at where New Plymouth is, go slightly to the left, there's a strip including Paratutu, which is on land. But as soon as it gets to the port jurisdiction, it stops and veers away. And so it's Rikatahi. Yeah.
Thank you.
So is there a potential jurisdictional issue there, Ms Carter? I was interested to hear you just say that there's it includes areas on the landward side of the Mean High Wheat Springs area. So I mean the jurisdiction of the regional council is the coastal marine area. Are you saying that this map takes the jurisdiction onto the landward side of Mean High Water Springs?
So two things here. One, the proposed coastal plan does include the coastal environment, and there's policies relating to the coastal environment, not just the coastal marine area, but there are no rules associated with the coastal environment.
Okay.
So that's one point. The second point is what I've got up here is from the Taranaki Regional Council's landscape study.
Oh, okay, not the coastal plan.
Not the coastal plan, but I can certainly try and get the coastal plan up. But the map is the same in the coastal plan as it is here.
Before you move off this, Ms Carter, who produced the study? Was it one of the consulting firms?
I would need. I look on the top of my head. I think it's Pofamiscal, but I can't be sure.
Yes, well, we've got an answer here, Denise.
I can clarify that I was working at the Regional Council at the time, and I've also got the study in front of me. So it was produced internally, and then it had some peer review from Pofamiscal, but the people that have been acknowledged were internal staff members. And I also note that apart from the peer review from Pofamiscal, there was no landscape architect advice.
Interesting. Thank you for that.
Ms Carter, I guess the point is we just need to know whether the planning maps and the coastal plan replicate that area, or whether they're different?
No, they're the same.
Okay. Okay, so just going back to my question then, what do we make of the fact that that this features Mikatahi is not included in the notified version of the PCP? What inference can we draw from that?
Well, I don't think that the work was done.
Okay.
That's my view.
Yeah, okay, thank you. That's a good, honest answer. Just my last question is, I guess it's a so what question. I mean, you would have heard my questions to Mr. Dingle, and I didn't mean to put him under any duress with asking those, but it made some fairly categorical statements at the end of his evidence, and I just wanted to test those. You accept that even if this feature is included in Schedules 8 and 10, it won't have the force of any rule in the proposed plan?
No, and the main concern that we have is the policy
Yes.
that I outlined, and it's an avoid policy, which makes it very difficult.
Yes, and you've drawn a distinction between NFLP 2, subclause 1 and subclause 2.
Yes.
And I understand what you're saying, but can I just put it to you that P2 clause 1 actually has a qualifier inherent in it, and the qualifier being protect the natural features and landscapes in the coastal environment from inappropriate activities. Now, you've already said that the port has a functional and operational need to locate in the coastal environment. Presumably, it's captured by the definitions of regionally significant infrastructure, wherever they might exist. And so wouldn't that indicate that port activities are not necessarily inappropriate activities, and therefore that isn't an absolute avoidance policy in relation to port activities? Would you accept that proposition?
I think it's a risky proposition. So being a planner who does policy work and resource consenting work, it's a risky proposition that someone won't consider the work that might go around Mikatahi to be inappropriate, given its outstanding natural landscape values, if that was to be confirmed.
Okay, let me rephrase that then. If the policy said protect natural features and landscapes in the coastal environment without the words from inappropriate activities...
It's a higher bar.
Yes, yeah.
Absolutely.
Okay. Yes. And I don't know if you were listening this morning to any of the questioning of submitters and officers?
No, unfortunately I had environment court this morning, so no.
Lucky you.
Yeah.
There was a discussion about the policy approach and letting the policy do the heavy work, and this was in relation to SNAs. Mm-hmm. And so the officer hasn't recommended any substantial rule relief to submitters. There's been some modifications recommended, but the relief where it is recommended is in the policy, particularly in relation to SNAs anyway, by creating a policy pathway through perhaps slightly relaxing the policy barrier, so that on a case-by-case activities, albeit as a non-complying activity in the SNA context, can be considered and hopefully get through the gateway that way. And I'm just wondering, using that analogy, whether with the absence of rules and the fact that activities affecting Mikatahi would be already captured by the archaeological rules and the SASM rules, is it any great new, I guess, inhibition to have a further policy layer added to this sort of resource?
So are you saying, and it's completely unchanged view, form NFL P2 unchanged? Is that what you're saying, or are you suggesting that there could be changes to NFL P2 that might accommodate?
To both actually, but firstly in its unchanged form.
Well, in its unchanged form, I still contend that NFL P2 1A is a high bar for the port. And I do take your point about it's saying inappropriate activities,
Yes.
and that goes down right down to the judgment of what is appropriate and inappropriate around the
Yes.
court.
So we,
That's relying on someone being particularly generous
Yes.
in their interpretation of that.
in the SNA example I gave you, and sorry to keep going back to that but it's just fresh in my mind, there's no definition of what's inappropriate and appropriate, but by implication, the listing of in the policy of regionally significant infrastructure and terms like network utilities and farm tracks and tracks and those sort of things sort of imply that they are appropriate or at least not inappropriate activities. And I'm just wondering whether we can draw the same line in relation to port activities, given that presumably they are defined as regionally significant infrastructure.
Yeah, I think, you know, you could run an argument if you were desperate. If the court was in a position where it had no choice and that Mikatahi is identified as an outstanding natural landscape feature, then
Sure.
we'd have no choice but to run that argument, definitely.
Okay. I mean, if the panel was to decide to include Mikatahi in the schedules, and I'm quick to say we haven't made any decisions whatsoever. What sort of policy alteration or relief would you recommend in relation to?
Look, I'd probably want a bespoke one for the port. To be fair, what I wouldn't want is to be tweaking this policy and the tweaks affect every single outstanding natural landscape.
Sure. Yeah, I understand.
I'd be concerned about that.
Yes, and we had that issue earlier this morning in relation to SNAs. So yes. Okay. Look, that's good. I've appreciated the discussion. Thank you for that. Food for thought.
Thank you.
Commissioner Coffin.
There was a fulsome discussion. I just have just a few further questions. You had heard my question earlier in regards to whether the port thought that there were other values in play other than cultural ones, and I just wanted to get your view, whether you would accept that there are other values at play other than those cultural values associated with an ONFL.
Yeah, no, I don't dispute the volcanic relationship, the geological relationship of the islands with Mikatahi, but I do also draw attention to the fact that it has been reclaimed. It's no longer an island. I mean, if you read the cultural values statement attached to Ngāti Te Whiti's evidence, it does make somber reading, but we are what we are, and it is what it is at the moment, and it is an island. It was an island, it's no more. So that association is slightly diminished, but I still think that it looks like a volcanic neck, and it looks like it's associated with the other islands offshore.
Okay. My next question is, I get the feeling from your evidence that you're not necessarily questioning whether it's a ONFL in the assessment that's been done by Mr. Bain, but you're really questioning whether it's necessary to identify the ONFL in planning terms. Is that correct?
Yes.
Thank you. Thank you, Ms. Carter. Could you please go to paragraph 22 of your evidence on page 5? This is policy 15. And this is a policy which we've had a lot of case law in our profession derived from over the last 5 to 10 years. Is that right?
I agree, very much so. Particularly to do with ports.
Yes. Now look, you added some evidence in, interpolated a comment that you don't think the right skill set's been brought to bear on assessing this ONFL as proposed. It may be unfair, but I'll let you correct me if I'm wrong, and you referred to the quality planning website and the multi-skills that were required in such an assessment. Was that the gist of why you introduced that new comment?
I introduced that comment in relation to the fact that I don't dispute Mr. Bain's qualifications, but it's to do with the level of investigation and assessment for the process to include Mikatahi. And I noted that Mr. Bain included that he had looked at the quality planning website in his evidence, and he quotes from the very same piece that I've quoted from in my additional evidence. So I just noted that he had looked at it and thought I would go and look at it myself and see what it says. But in addition to what Mr. Bain says, it also says that these things are multidisciplinary, that it does require assessment from various aspects, including statutory planning, historic heritage, cultural and natural science, and that work should be peer reviewed as part of the process. And so I just thought that it was important to add in that context around relying on Mr. Bain's evidence, even though I do not dispute his professional ability in this space.
So if you look at the list C1 through to C10, we're looking, just going through them, there's a strong emphasis on landscape expertise, yes?
Yes.
Some ecological factors, yes?
Yes, yes.
And both cultural and spiritual values and historical and heritage associations.
Yes.
So in terms of, you do accept that in our decision-making role, we have to make our decisions based on the evidence in front of us.
Yes.
And particularly in matters of this type of interpretation, that requires us to hear evidence from experts, and if there is no other evidence, we can't apply our own value judgments or anything. We've just got to run with the evidence, don't we?
Yes.
And given the fact that we do have, or will have and do have expert evidence on both cultural association matters and also landscape matters, apart from your planning evidence, statutory planning evidence, going through the policies and things, we don't have any other way of making a decision but to listen to the expert evidence we have. Is that as you understand the process?
Oh, absolutely, yes. And it's that bringing in the other policies that, from a planning point of view, and setting it within the context of the court, that I felt was missing from the Section 42A report. That's why I think that bringing in the other evidence that's important to consideration of whether something should be in or in FL is something that hasn't been done here.
So what other evidence are you referring to?
So I was thinking in
that's
terms
missing?
Well, in terms of the higher order planning documents, the Section 42 report, the planner's report, doesn't discuss Policy 9 for ports, and it doesn't discuss Policy 6 in relation to coastal activities, in order to bring that balance.
But when you're making a decision for the purpose of Policy 15, with our decision around whether this should be classified ONFL or not, does the balance come in? Like you say that this is a policy about protecting, defining natural features, natural landscapes. The other policies you've introduced are equally as important, but this task at hand does require a certain expertise, does put a requirement on the council to look at these issues sort of in the context of Section 15. policy 15, I mean.
Yes.
Is that fair, or
No, I agree
balancing
that-
out this task by referring to other policies? I'm just trying to get to the nub of what's been missed.
Okay, in terms of the policy 15,
Yes.
I agree with you. I don't think a lot's been missed.
Okay, thank you for that. There's a supplementary here from Commissioner McMahon.
So sorry, I thought I had my go earlier. Is it possible that, I mean, if policy 15 directs the inclusion, could we say that the other policies such as 6 and 9 and 13 might then shape the policies and rules that affect the inclusion? So